Okay, I'm going to ask the secretary to bring in the candidates now. Thank you. Please bring in the candidates. Good morning, Judge Dafu.
Good morning, Chief Justice and all other commissioners.
Did I pronounce your surname correctly?
100%. I know there are differences, but I prefer it the way you do it. Thank you.
Thank you very much. How are you this morning?
I'm feeling fine, thank you, Chief Justice.
CJ? There's no one there.
Thank you, thank you. Secretariat, the commissioners who are on the virtual platform.
We're here, Chief Justice.
Or you can hear?
Yes, thank you, Chief Justice.
Oh, but
Chief Justice is gone.
Oh, hello, Sobon. Thank you. Okay, all right. Okay, we have started. Judge Dafu, I am able to respond on behalf of all the commissioners that we are all fine.
Thank you.
Yes. Thank you very much for availing yourself to be considered for appointment to the Supreme Court of Appeal. We have adopted selection criteria and guidelines which assist us as commissioners in asking candidates questions that will help us to make up our minds about the suitability of each candidate. All of us here want to make sure that you are treated with respect and courtesy. And when we ask you questions, don't ever think that there is anybody who wants to humiliate you or anything like that.
Thank you.
We nevertheless will be robust where we need to be robust, but throughout our questioning, we will bear in mind that you need to be treated with respect and with courtesy. So I will ask you questions. After I'm done, then the Deputy President of the Supreme Court of Appeal will ask you questions, and thereafter the Minister and other commissioners. Okay. MPA was from Buckinghamshire. Yes. And you were appointed as a judge in 2011, is that correct? 2012?
Yeah, from the start, from the 1st of January 2012.
Yes. So that means you have been a judge now for just over 10 years, 11 years?
No, I will be, at the end of the year will be 12 years.
At the end of the year, you'll be 12 years. Okay, all right. And during that time, you have sat in criminal matters, civil matters, motion court, civil appeals, criminal appeals. Is that correct?
That is correct.
And you have also had an opportunity of acting in the Supreme Court of Appeal. Is that correct?
That is correct, yes.
Did you have one acting stint there, or have you had more than one?
No, I had 2 acting stints of 3 months each, or the 2 terms, which is then 6 months in total.
Yes. And how did you find it?
I find it unbelievable. It is something that I dreamt about, and I must say that the kind of work and the submissions by counsel were obviously of a bit higher standard than you'll get in the High Court, and that was refreshing to be involved in some intricate matters, and I find it very, very satisfying.
Are there branches of law that you found yourself involved in at the Supreme Court of Appeal that you had never been involved in, either in practice or in the High Court?
I must say that in the one case of the unlawful competition, I haven't been doing that as a judge, but I've done it as an advocate. So, save for that, the other matters I've been doing I was accustomed to that.
Yes.
And I must, for example, I also did a income tax matter. Whilst in the High Court, I think I only did 3 or so. But again, as attorney and advocate, I did a lot of tax work those days.
Yes. So if you were appointed to the Supreme Court of Appeal, what value do you think you would bring to that court?
Chief Justice, I think I've got a lot of overall experience. The last couple of years but let me start at the beginning. As an attorney, for example, I was a conveyancer as well. So I did a lot of conveyancing, all property law issues, administration of estates, insolvent and deceased estates, trust law, divorce matters, and then obviously the criminal and matters that I dealt with both as attorney and advocate. And then, as my program, or as my evolved in my business as an advocate, I did a lot more administrative work and also commercial work, trust law, company law, that kind of thing was that I dealt with, and I'm sure that I can make a huge contribution to the SCA pertaining to all commercial matters, and also administrative law. So I'm satisfied that I will be able to bring that experience. But I think more important is that my work ethic, my diligence, the way that I deal with my matters and finish them in time and quickly, and make sure that I understand the matters that are placed before me and do proper research and then write well-researched judgments, that will bring a lot to the SCA with great respect.
Now, You do know, of course, that the Supreme Court of Appeal also has constitutional jurisdiction, is that right?
That is correct, yes.
Yes. Have you dealt with matters, whether in the High Court or Supreme Court of Appeal, where you had to declare legislation to be constitutional invalid?
No, I haven't done that. It was not necessary up until now, although I have dealt with many matters where I had to deal with constitutional issues and balancing the various bills, various rights in terms of the bill of, in terms of the Constitution. So, but I haven't declared any legislation invalid at this stage.
Mm. Are you familiar with what the approach is if you are called upon as a judge to declare legislation inconsistent with the Constitution and invalid? Are you familiar with how you go about that?
Chief Justice, yes, there should be, in the High Court, definitely in terms of Rule 16, there should be proper notice to all the relevant stakeholders so that everybody that has an issue, the various departments and stakeholders, that they have the right to respond, and also for amici curiae that want to deal with issues, for them to also to apply to be to make presentations to the court. So one cannot do that without everybody taking part in the process.
Yeah, no, I understand, but I was more interested not at the procedural aspects that precede the actual hearing. I was more interested at the level where now you are writing a judgment. Now you have had argument. You have to decide whether the legislation is inconsistent with the Constitution and therefore invalid, and consider remedies or not. Are you familiar with how to go about that?
Yeah, the judgment is made, but it is normally suspended to allow for rectification by Parliament. Obviously, if it is the judgment is made, it's got to still have to be. Should be taken to the Constitutional Court for a final. That is now as a High Court judge for final adjudication or final determination of the constitutionality.
Yes, but before you come to the point where you talk about the remedy, when you are just talking about, you want to answer the question, is this statutory provision or is this legislation inconsistent with the Constitution and therefore invalid? Are you familiar with where you start and where you go up to where you end?
Chief Justice, I must say that I am not that familiar, but the point would be is that the legislation should always be tested against the Constitution, and if the legislation is not cannot be accepted as constitutionally valid, then you can make the order of constitutional invalidity.
Yes. In terms of the judgments that you have written and that have been reported, are you able to take 1 minute or so to share with the commissioners which one you regard as the most important and what legal principle makes it important that it enunciated?
Are you referring to only one matter?
Yeah, just discuss one, and just 1 minute, maybe I'll give you 2 minutes,
Yeah.
say this is the case, this is what it was, this is the most important one as far as I'm concerned,
Yeah.
and this is the legal principle
Yeah.
that makes it important.
Well, I think if I can refer to two more recent ones, it's the first one is the West Station versus Castro matter, where it went to the SCA in Centric Insurance Company, where I dealt with and interpreted an insurance contract and the exclusion clause. And the matter went on appeal, and Kashali JA, in a unanimous judgment, dealt with my views on that. That may have been the end of the story, but then what happened is with COVID and many insurers trying to get away from liability, indemnity liability, didn't want to accept the claims, and then in the matter of guard risk insurance, the SCA was again asked to deal with the matter, and reliance was placed specific on Centric. And as I said, Centric referred to my judgment. The other one was that maybe may be relevant is the Lawrence matter, where I just said that the shortlisting proceedings were unlawful and unconstitutional, where the appellant, the SCA, also confirmed the attitude that I took there, bearing in mind how Section 174 of the Constitution should be interpreted. And I think those two, in short, would be. The last one, for example, is the Misimango case, where the Constitutional Court accepted the way that in which I applied Section 342A of the Criminal Procedure Act, insofar as I closed the case of the accused persons without them testifying because of delay, and the court was satisfied that the proper procedure was taken and the exceptional circumstances existed for the order that I made. Those are off the cuff the three that I can think of.
Yes. There are at least two types of discretion in law. Maybe there are three, but at least there are two. Maybe there are three. Do you want to share with the commissioners which ones they are and what the difference is between the two types of discretion?
Yeah, it's always difficult. It's a loose and the wide and the strict discretion. When it's a loose discretion,
I'm sorry, please, I'm sorry to interrupt you. Just start afresh. There's something I may have missed when you started responding. Just start afresh.
Yeah, as I see it, it's a strict discretion or a loose or a wide discretion, and in the one case, the discretion of the court making the decision should not be set aside by the higher court if it was a strict discretion. If it is loose, then it would mean that the Court of Appeal can then decide that the one way or the other, the discretion was incorrectly executed or exercised, and make an order.
Are there restrictions in regard to both as far as an appeal court is concerned, or is the position that in regard to the one type of discretion, there are restrictions, limited grounds upon which an appeal court may interfere, but in regard to there are no limited grounds, or there are still some limited grounds there too? I'm trying to understand whether your answer says exactly what I'm saying, but I'm not sure whether I can hear that in regard to one, seems to be, you are saying there are limited grounds for an appeal court to interfere.
Yeah.
In regard to the other one, I'm not sure that I understand what you are saying.
Yeah. I must say I must also now think about it.
Remember, you are nominated for the Supreme Court of Appeal now. You have to give guidance to the high courts and lower courts on matters of law.
Yeah. No, that is so, Chief Justice. I must say that I'm at this stage a bit confused, and I should not be. When the discretion is a strict discretion, then it is then the High Court will not interfere with the discretion unless it is clear that it was wrongly decided by the court. With a loose discretion, the court may decide, well, we would have exercised the discretion otherwise, and then make the order that it wants to make.
Thank you. Deputy President Betze.
Thank you, Chief Justice. Good morning, Judge Daffo.
Good morning, Deputy President.
Did I understand you correctly to say that you acted at the SCA for 2 long terms? We have long terms and short terms.
No, I said for 2 terms. The one was in the second term of 2022. The third term of 2022 and the second term of 2023.
The third term would have been 2 months, August, September.
That's correct, yes.
And second term of May would have been 1 month, May.
Yeah.
Although your appointment was effective from the 1st of April.
That's correct.
NADEL has expressed some reservations concerning your candidature on 2 bases. One being, they say that you do not have sufficient appellate experience, and the question of your age. Insofar as the latter, you would have, if recommended for appointment, essentially 3 years at the Supreme Court of Appeal.
That is 3.5 years, yeah.
I didn't get the answer, Judge Daffo.
No, I say it would be 3.5 years.
Yes.
Do you want me to comment on Nadel's report?
Yes, please. Insofar as those 2 issues that they have raised.
Well, as I see it, they've raised one issue, and that is and that's my age. Not that I didn't have sufficient experience. They specifically say the candidate has made significant contribution to the development of the law and is both qualified and experienced for consideration, as paragraph 2. And then in 4 they say we are, however, concerned about the candidate's age and that he will only have a few years at the apex court. What I can say in that regard is that, first of all, I thank them for the positive report that they've given. The issue of the age can be dealt with at the following level, and that is that I've got 3.5 years left. You will know that the judges can perhaps get between 12 and 15 appeals per term. If you work even on an average of 50 per year, it would mean that I would be able to be involved in 175 appeals, which is a lot. And if you look at petitions, for example, at 2 per week, it would be over 350 petitions in that period. And if I then look at what happened in the recent past, Judges Dlodlo and, if I can just have a note, and Plaskett, both of them only served 3 years from 2019 to 2022 as permanent judges. And I must say both of them have made valuable contributions by way of their judgments. Then Judge Gorvin was appointed in 2021 at the age of 67, so he'll probably have 3 years also. Judge Wiener was appointed last year, and she will have probably 2 years. I'm satisfied that both of them also have they've made contributions, valuable contributions, and I feel young, and I think I'm still energetic, and that I'll be able to make contributions, worthwhile contributions.
Thank you. And there's also the Black Lawyers Association also raising a concern about what they characterize as your lack of sufficient appellate experience, and of course, what they call your advanced age.
Yeah, Deputy President, I just want to know, are we going to refer to anything else in that report of theirs? Because there are serious allegations made in the report that I would have believed that in terms of the guidelines, they should have dealt with it properly. I'm referring to clause 40. There's no sufficient substantiation for the allegations that they're making, which you haven't raised now, and I haven't given proper notice of these allegations. I'm referring you to paragraph 1.2, and I'm not going to read that because if that's not going to come up, then it's the end of the story. But those are serious allegations pertaining to my dignity, and I didn't have an opportunity to get full substantiation thereof. And I've got many friends in the BLA that deny that version.
Well, I was only interested in the query raised about your lack of sufficient appellate experience and your advanced age.
Yeah, no, that's why I say if that is all that you're concerned about, my answer is the same as in respect of Nadel, is that although I only had the 2 terms in the SCA, I've had numerous experience and years of experience as sitting in appeals and reviews in the High Court, especially the last few years as the presider because of my seniority. But if one also looks at the JSC guidelines, the acting experience is important, but that should not be the overarching experience. And I still believe and maintain that I can make a proper contribution.
Thank you. When you were asked by the Chief Justice to explain to the Commission the difference between a wide and a narrow discretion, I must confess that the impression I gained was that you couldn't adequately articulate the difference from someone of your seniority.
Yeah, I must say it's perhaps because I'm a bit under stress here, and it's the two versions, either the narrow or the strict versus the wide, and the effect thereof. But I'm certain that if I can just go back to my notes, I'll be able. But so I probably, if I changed it around, then I changed it around. But I understand when a court of appeal can interfere and when it cannot interfere, on what basis it can interfere if it's the case.
And whilst you were being questioned by the Chief Justice, you asserted that you are diligent and industrious.
Yes, that's correct, Deputy President.
The concern which is shared among senior colleagues at the SCA is that when it comes to judgment writing, your judgments were not concise with linear reasoning in support of the ultimate outcome, and that you tend to delve too much on facts, citing well-known principles, needlessly quoting familiar precedent. What's your response to that?
Yeah, I must say, Deputy President, that I've looked at the email, the trails of this year. I haven't got last year's with me. I know, for example, in one case, it was said that I should shorten my judgment. I was also said that you should change paragraphs, 1 or 2 paragraphs to, but what I will say is and I say that without fear, is that my email correspondence will show, and I've looked at that the judges were satisfied with the reasoning, and if I may quote that, I can do that. I know there's confidentiality in conferences, but the point is that I was told, for example, well-written judgment. I was told that the judgment is in order, say, for example, change paragraph from this to that. And I'm also glad that in certain instances where I had to give notes to presiders, that they were satisfied with the notes that I've given. So it's possible that I perhaps put more into a judgment, but as far as I'm concerned, none of my judgments have been deleted and rewritten, so to speak.
And there was an instance where the decision was that the matter failed to be remitted to the High Court for it to deal with the merits. But your judgment went on to deal with the merits of the case, which in effect would have bound the hands of the High Court, so to speak.
Yeah, Deputy President, that is the matter where you were presiding. That was dealt last year. And all that I want to say is you are correct on the basis that I initially, because my view from the beginning was that the appeal should succeed, and my judgment became, the orders that I granted became eventually the majority's orders, although you and another colleague differed not differed, but you wrote separate judgments. What I initially the intention was, my view was that the appeal should succeed and the application should be dismissed. And on that basis, I dealt with the merits. But I was then convinced that, and remember, I was not the scribe initially, so there was a minority judgment. And then, whilst we were consulting, it was pointed out to me it should be better to not uphold the appeal and dismiss the application, but rather refer it back to the High Court to be dealt with by a different panel. And that was the ultimate decision. And as a result thereof, I took out a number of the arguments that the points that I've raised in my judgment pertaining to the merits. That is, the judgment is with me here. The merits have not been, I've referred to many aspects pertaining to merits initially, which I took out because of the change pertaining to the order that we were in agreement as a majority.
You know, of course, that in terms of the practices of the SCA, before you circulate a judgment, you should satisfy yourself that if I was sitting alone in the High Court, this is the judgment that I would sign and then deliver.
That is so.
And there was an instance where I was constrained to send out an email to the members of the bench to say that I haven't got the luxury of time of reading one and the same judgment 10 times, and that those who wrote judgments must consider their judgments carefully and indicate to me when they are satisfied that these are their final judgments.
Deputy President, that is correct. I can tell you in the one case that I was involved, where the scope was somebody else, the argument was is because we were uncertain after the conference as to the outcome, the scribe decided to send to circulate his draft on the basis that to get clarity from other colleagues before it was sent to the researchers. In one case, I did the same, where we were also during the conference, there was uncertainty as to whether we will be able to agree with each other. And I send it out to the colleagues saying that I'm sending it simultaneously to the law researchers, and when I get it back, I'll send it to them, which I've done.
In paragraph 16.1 of the questionnaire, this is what it asks of each candidate. List the cases where you have written a judgment, not more than 10, which you regard as being most significant, and why. You have listed those judgments, and they appear on pages, paginated pages 10 to 12. And looking at those judgments, in my view, they dealt with questions which are already settled. There was no new principle or a deviation from established principles or clarification of any judgment. That with simple matters of statutory interpretation, interpretation of contracts, and so forth. What do you say to that?
Deputy President, are you referring to paragraph 18?
16.
Yeah, well, I've looked at 16.1. Which one are you referring to?
All of the judgments that you have listed there.
Well, the judgment, the first judgment is the one of the Minister of Higher Education, the 16.1. That judgment, the Minister got leave from me to go to the SEA. He decided to withdraw his application, and he arranged that the Act be changed. So, I mean, that was a serious, and that dealt with the jurisdictional requirements of Section 41A of the Higher Education Act that have not been met. So that was, and they substituted Section 42 from September 2017. So that was a very important judgment. The Oosthuizen Castro judgment was also important because that's about the exclusion clauses in insurance contracts. The two senior advocates that appeared before me couldn't give me precise arguments on the issue. The one got the previous night a judgment from, I think, New Zealand or Australia. And that judgment was important insofar as the SEA agreed with me, and then the importance came afterwards pertaining to COVID-19 and the insurers' allegations that they can rely on the exclusion clauses. So that's an important judgment as far as I'm concerned. And then the issue, well, there are others also. The ex parte, the National Director of Public Prosecutions, where the director attached the bank account of Baroda Bank, which with Nedbank, the whole bank account, which they couldn't do because they was looking for the money of one client of Baroda Bank. The other one of Sequoia was, there were different views by the provinces in this country, and we were called upon to deal with the question of representation by a legal practitioner, whether the child was entitled to an automatic right of review. So, and we made and it was a full bench that was set aside there, put there. In Fredericton, the legality principle was applied. So, the Mr. Mango case that went to the Constitutional Court, Ramabele, that case, there was never in the High Court ever a judgment pertaining to Section 342A, where you can close the defendant, the accused cases. And I said this, justice is a one-way. It's not a one-way street. If it was fair to the state, it must be fair to the accused, and other way around. So, if you said I must go to paragraph, well, I don't know which other cases I must refer to, but those are the cases that are important.
Thank you. I'll conclude by asking you a direct question. Do I understand your response to be that those cases that you have listed under 16.1 introduce new principles of law or departed from established ones or dealt with new or developing areas of the law?
Well, not all of them, but surely the question in 16.1 is which you regard as being the most significant. That is the question. And I refer to that. But then in paragraph 18, the question there that's why I asked which paragraph you're referring to, because in paragraph 18, the question is, what would you regard as your most significant contribution to the law and the pursuit of justice? That's the question. And I dealt there with those cases, and the abuse of process in the MBD securitization case is very important. That's an old lady that signed a document in the Eastern Cape, and then they took judgment against her in the Free State by attorneys from Gauteng. And I referred that matter to the Law Society and to the Minister of Justice, because it was clearly that there was a serious issue there. And then my judgments pertaining to criminal cases, I am very adamant that we should do something about gender-based violence, and my judgments in criminal cases are clear that I've got a serious issue with that, and people that offend in my court in those regards, they must know that they will get serious penalties, sentences against them. And the Nakashle judgment is also only about the record keeping, because we've got problems in the high courts. All the high courts, we've got problems with the record keeping of matters that come to us on appeal or review. And I know that the Constitutional Court has written 3 judgments on that, but they didn't do anything to tell the department what to do to rectify the problem. And I believe that in that judgment I tried to indicate what should be done to ensure that convicted persons are not acquitted because of lost records.
Thank you, Judge Dafu. That's where I'll leave it. Thank you, Chief Justice.
Thank you, Deputy President.
Thank you. Before I go to the Minister, I will just mention for the benefit of those commissioners who might have been saying how, but we agreed 2 questions. What's happening now? We allow the head of the court, in respect of which we are interviewing a candidate, more leeway. So the 2 questions usually won't apply to the head of the court that is being, in respect of whom we are interviewing the candidate. So that's the reason why. Okay, Minister.
Thank you very much, CJ, and good afternoon, Judge.
Good afternoon, Honourable Minister.
Yes, I see, like myself, you are an ardent cyclist. I hope you also extend it to privileged kids in the Free State.
Yeah, no, I'll try my best to do that. I must say that I haven't done it with cycling, but I've sponsored a soccer team of my gardener, kitting them out totally, but not with bicycles at this stage.
Okay. There is a judgment here on the ENGO and others versus the Premier of the Free State. In paragraph 1 of the judgment, you have made a remark about how you feel about writing this judgment. I'm not sure if you have it or you remember it, but
I remember
just to remind you a bit.
Yes, I remember it, Minister. That was the uneasiness that I had with first of all, the kids in the Free State, the social welfare of them, their housing, etc., against the province's ability to support and to provide financial means. That was for me a very serious issue because I knew at that stage that the province was under financial constraints. And I think that's what you referred to.
Yes. So what I'm struggling with upon reading the judgment, I could not understand, or I was struggling to understand why did you feel it necessary to put your personal feelings, how you feel about it.
Well, it's a balancing trick because I had to look at first of all, the obligations of the province in terms of Section 195 of the Constitution, and I had to look at the rights of the children to education, to housing, etc., in terms of the Constitution, Section 28, and all the other sections dealing with housing and education. So, in Afrikaans,
what I want to understand is, did your feelings on this matter influence the judgment?
No, not at all, because eventually I made an order that the province must pay because of I think it's Constitutional Court, the SCA judgments indicating that if you've made a promise as a department, you must comply in terms of the promise. So as a result thereof, and this matter was dragging on for many years, and I just mentioned, as a human being, that it was difficult for me to do this balancing trick. But I eventually did that in favor of the children.
Thank you, CJ.
Thank you, Minister. Mlambo JP.
Thank you very much, CJ. Good afternoon, Judge Duffy.
Good afternoon, JP.
You correct me if I'm wrong, the only appellate court you've acted in is the Supreme Court of Appeal.
Please repeat.
The only appellate court you've acted in is the Supreme Court of Appeal.
That's correct, yeah.
Okay, not the LAC,
No.
not the CAC.
No.
Or not even the CC.
No.
Okay. Thank you, CJ.
Thank you. Commissioner Matolo Zlepu.
Thank you, Chief Justice. Good morning, Judge Duffy.
Good morning, ma'am. Good morning.
Okay, I heard you saying that the BLA comments about your attitude towards attorneys is an attack on your dignity. Please correct me if I'm wrong. But I think for me, that's the issue that relates to transformation. If you had made a statement, and it's not only once or twice, the BLA members, they say that your attitude towards attorneys being judges is a concern to them. So, and you should have responded to them if you felt they were incorrectly quoting you. But from what I can see, and even from BLA members, you still maintain the same. Can you please clarify me?
excuse me, can I just ask you to just clarify, do you say that I've made comments that attorneys cannot become judges?
Yes, Justice, if
Well-
you look at paragraph 1.2 of the BLA's
Yeah, well,
comment.
first of all, that's the issue that I raised with the Chief Justice, is that as I read the guidelines, that is such a serious issue that you should have given me sufficient substantiation. Tell me where did I say that, at which occasion, and who were present there. Because I can promise you that from the time that I was still an advocate, a gentleman like Mr. Tekiso Musi became a judge in our court, and he became a judge president. And I regarded him as proper. He was 19 years an attorney before he was appointed to the bench. I had good relationships with him, and I had always, and the reason that I became a chair of the Free State Society of Advocates was because of that, the way that I tried my colleagues to understand that it is high time for attorneys to become judges. Mr. Justice Rampai was my colleague. Mr. Lakali was appointed together with me. I've learned so much from him as a gentleman, as a judge. Mr. Rampai the same. And furthermore, I was the one that dealt with the Future Leaders Symposium in Bloemfontein in 2011 because of my as chair. And what did I do? I asked Madam Justice Molamela, at that stage, still 2 or 3 years at the bar, to give one of the keynotes, as one of my keynote speakers. She was an attorney that I knew well. Why would I ask her as an attorney, a previous attorney, to address bright advocates if I believed that attorneys were not properly or not suited to become judges? I can give you more examples. I can, for example, tell you what I've said when I was introduced as welcome to the bench, where I said we've got to make sure that we improve the skills of all our black colleagues so that the pool must be increased and that there's more time for more of them that can become judges. And what I've said there has been repeated over and over in the Judicial newsletter. I've quoted that. Well, I've got that. Madondo, AJP has referred there to. Our previous CJ has referred there to. The lack of chances of our black people to get their practices as attorneys off the ground. And we must improve their skills. And Justice Molamela gave a speech about the SA Sajay, and therein she also mentioned that training should be given. Sajay was there on the point of being implemented at that stage. And it's, I can go further. At my speech at the last meeting of the Attorneys Association in Bloemfontein in 2018, I gave a speech there, and the president of NADEL was there, the president of the BLA was there, and those people would know how I dealt with transformation and how I said that we must make sure that we must understand the LP, the Legal Practice Act is there to help us with transformation, and we must make sure that there's proper education for all. And I can't take it further. And what is strange to me, if I was so against attorneys, why would my colleague Mbele sent me a message of goodwill just now? Why would I be asked to act as acting deputy president for how many terms? If I was against attorneys to be appointed as judges, whilst there are many attorneys on the bench.
Judge Tafu, you have responded to the question, but earlier on you seemed to complain that something went wrong with the procedure. I don't know whether you were saying you were not given these allegations prior to today, or whether your complaint is that it is not substantiated as far as you are concerned.
Mr.
What is the position?
Well, the position is that I've now allowed the question to be put in, and I've dealt with it. All that I say is procedurally it was incorrect to allow this to be placed on record without sufficient substantiation. But I want to go further.
Hang on one second. Hang on 1 second. Are you saying that that document that has got that allegation was not given to you prior to today to enable you to comment on it?
No, Chief Justice, that document was given to me. The point that I raise about is that if you look at your own guidelines, it's not good enough to say this person is a racist or anti-transformation. You've got to substantiate. And that is the problem. There's no substantiation. They just said, it's sadly worrying, sadly has a worrying and deeply held view that notwithstanding the experience which they may have in the practice of law, attorneys will never, not black attorneys will never acquire enough skills to become judges. This view has not only been expressed to attorneys, but also to his colleagues in the Free State Bench, the majority of whom are black and former practicing attorneys. Now, all that I say is, I've got a letter of a colleague, an attorney who is on the Black Lawyers Association. He's a member of the BLA.
Yeah, but don't mix things, Judge Dafu. Somebody says you made a statement that attorneys either should never be judges or are not good enough to be judges. You get given that in advance. It gives you an opportunity to say, I never said that. Or if you want more information, you can ask for more information, isn't it?
Chief Justice, I beg to differ with great respect. Your guidelines say that if the reputation or dignity of a person is attacked, that allegation must be provided with sufficient substantiation. It's not the duty, it's not on me. I'm not the accused here.
Hang on, Judge Defoe. I'm putting questions to you. You're saying you are differing with me. I was just putting questions that when you are given a document where somebody says you made this statement, if you remember or you know that you never made such a statement, isn't it the right thing to do is to deny that? Well, if you are not sure, you want more information so that maybe you might have made the statement, but in a different context, you might then say, well, I would need more information. So I'm asking whether that would not be the way one would be expected to deal with it.
Yeah, well, the manner that I try to answer is to show that I've never made such a statement, bearing in mind the history with our previous Judge President Musi, Judge Molamela, all my other colleagues, and the fact that I've been allowed to be practicing or acting as acting Judge President. Nobody has ever complained. There was no, so I deny fully and comprehensively that I've ever said that. All that the point that I'm raising is actually now beyond reproach because I've dealt with it.
Yeah.
And I can promise you, I sent this to a colleague of mine from Gauteng, and when he read this, he on his own sent me a letter. And I've got the letter, but I'm not going to give it to you because I don't want to put his name in it.
No, I think you have made your point, Judge.
Can I just say one thing also?
Yes.
Is that very recently, a colleague of us, or an attorney, passed away. I went to the funeral procession, or the what do you call it, where, and I was the only white person in any event there. There was a program. The program director asked me, the program had already people named as speakers. He asked me to make a short speech, which I did. The overall
Okay,
attitude.
just Jafu, I think we hear the point you've made. Commissioner Matolo-Lepu, were you done or not yet?
Thank you, Chief Justice. I think I'm done.
Thank you. Commissioner Dodovu?
Much better. Thank you, CJ. Good afternoon, Justice Duffy.
Good afternoon.
I only have one question, and this question has been traversed by the speakers before me. I want to really understand one thing from you. Firstly, there is no question that you have sufficient experience in the bench, that you've contributed in respect of your contribution in respect of jurisprudence. But there's only one concern, and for me it's a serious concern. You only apply now after serving more than 12 years as a judge. You served very, very little at the level of SCA and not any other appellate division. Now my question would be, because you are left with 3 years or just over 3 years, what is it that is really, really exceptional, that is unique and special, that you can offer and contribute if you can be appointed, bearing in mind that you are going to only serve for over 3 years? Thanks.
Yes, all that I can say is hard work and diligence, and to be efficient as far as possible, and to make sure that the judgments that had to be written by me be written, and that I give proper contributions in the conferences, which I've done. Because of my knowledge of practice and procedure and things, and I can give two explanations to you. First of all, a judgment went out, which wasn't properly checked. When it was already delivered, I picked it up, I was on the panel, and I had to see to it that the judgment be rectified. The other one was where the panel wanted to make a provisional liquidation order on appeal. The appeal was upheld. And I said, but you can't just make that order. A provisional order must have a return date. And there are practice directives by the various courts. In Mr. Malambo's court, there are practice directives. You've got to comply with that. And as a result, I helped my senior colleagues with it. So I think I can make valuable contributions. Thank you.
If I may just make a follow-up, CJ. You say you'll work hard and write well, and for me, that is not exceptional. It's not, I put it to you that it's not exceptional and unique. Every judge can do that. But I'm saying to you, you are left with 3.5 years before you retire, and you want to be elevated. And I want to consider that, but I don't see anything exceptional, and I want you to show me that I don't see that is exceptional and unique. That will place you ahead of other candidates and therefore propel me to consider your appointment.
Yeah. Commissioner, I can just say, look at my track record with great respect, and you can look at what the General Counsel of the Bar has said. They've in fact said it much better than I said it in my questionnaire. There's no issue about my commitment to the values of the Constitution, to my knowledge of the law, and also the manner
Judge
in which
Dafo, I'm sorry. Surely you know what it means when somebody says they want something exceptional.
Yeah.
You can't tell them your commitment to the values of the Constitution, because there are so many of us who have that commitment.
You are right. The point that I want to make is my track record.
Sorry?
My track record is the point that I want to make. If you look at the timeous delivery of judgments,
Yes.
the well-researched judgments, even if some of them have been set aside on appeal.
Okay, all right. Thank you. Commissioner Moimang. Commissioner Moimang is out.
Oh, thank you, Chief Justice. Good afternoon, Judge Dafu.
Good afternoon, Professor.
Just one question from my side. There's a judgment under 16.2, page 14, right at the top. Machabe Local Municipality versus McDonald.
Yes.
Yes. The question that I want to pose is the opportunity that you had to develop the common law around an ownerless property, as you correctly pointed out that you declined.
Yeah.
Maybe if you can just probably elaborate more on that. But the second part of that question is, given the fact that the Constitution makes provision for expropriation under Section 25(1) and 2, but also the Municipal Systems Act, Section 8(1), and the Municipal Structures Act, Section 83(1), gives the municipality the power to expropriate. Was the decline prompted by the fact that there are other avenues in case the municipality wanted to use this ownerless property for public good or in the public interest? Thank you.
It is so that I could have decided to say that there should be a total change from where the what we call bona vacantia, that ownerless property, normally in terms of years gone by and from the Roman times, were then regarded as the state or the property. My view was that with the evidence I had available to me and the arguments that were put to me, is it would be wrong to say that the third-tier entity like the municipalities will become owners, because you must remember that the standard principle is that the state becomes the owner, and the state is the national government. And I think that the Constitution makes clear the difference between the national, provincial, and the municipal and the municipalities. So there's a difference between them, and I just felt at that stage it would be incorrect to develop the common law. If I've made a mistake, they could have taken me on appeal, but that was my view. That we can't deal with it. That any property in municipalities can now become the ownership of the municipalities. The state is taking control of those properties. The national government.
Is your understanding of the state not inclusive of all the three spheres of government?
I'm not sure whether I follow. If I've made a mistake, the municipality could have taken me on appeal. I'm satisfied that it wasn't the right thing to develop the common law, and that's my final answer.
Thank you, Justice. Thank you, Chief Justice.
Thank you, Commissioner Nochesi.
Thank you, CJ. Good afternoon, Judge.
Good afternoon.
At the SCA, the courts sit as a panel. You are a panel of judges, either 3 or 5. And the judgment ultimately that is produced is one. Is it beneficial for other judges who sit in a panel to comment in a judgment, make proposal for certain changes to be made, or is it something that demonstrates that the candidate or the scribe is not yet a fit person for that court? How do you regard, what are the benefits of the panel sitting of judges?
Yeah, well, I must say that I haven't been in one panel where the judgment, the first draft, was accepted as it is. The whole idea is that at the first conference, the scribe, everybody is giving his input, and then the scribe will provide the judgment. And thereafter, it's circulated, and often there are extra comments from people, and then a final draft will eventually be finalized. Now, I, for example, can refer to one aspect where in a competition law issue where the scribe asked for comments, and within an hour I gave my comments, and that were included. So that's part of the judgment writing and conferences.
Last question. The presiding judge in a panel, is he one among equals or a principal in that panel?
Well, I think he's one among equals, but most definitely I found that you get so much from the presiding judge, and they're actually working very hard. So they've got to give guidance, and they have got to check all the judgments of the scribes. So although they are equal, surely they've got a proper function to fulfill.
Thank you. Commissioner Marumwagai.
Thank you very much, CJ. Good afternoon, Judge.
Give me you, Professor. I was wrong. Sorry, Professor. Good afternoon.
No, thank you very much. I have two questions for you. One is more procedural, and the other one is more substantive. I'm not sure if when you were acting, you had a chance to do the special applications for special leaves to appeal. But nonetheless, I just want to give you a scenario, and I just want to see how you'll deal with this scenario. Assuming that there is a judgment from a judge sitting alone in the High Court, where the judge dismissed an application, and then an application for leave to appeal that judgment was brought, and the judge dismissed that application. And then the litigant who lost decided to appeal not to the full court, but to the SCA. First, I want to understand, is that judgment appealable? Depending on your answer, how should those two judges who are dealing with special leave to appeal have to deal with that kind of judgment? No. I'm not sure if you understood the scenario.
What judgment is appealable?
Remember I said there was a judgment which was dismissed. Then the litigant applied for leave to appeal against that judgment. Yeah. Then the judge dismissed the application for leave to appeal. Well, then the litigant went to the Supreme Court of Appeal, not to the full court.
No, you go you go on a petition to the Supreme Court of Appeal. You don't go to you go on petition to the Supreme Court of Appeal. The unsuccessful litigant.
So is your answer that judgment is appealable?
Well, I don't know what the facts is, but if we accept that the judgment is appealable, the moment that judge in the High Court dismisses the application for leave to appeal, you as litigant is entitled to go on a petition to the SCA.
Okay, let's assume that it is. How then do you deal with it as the two judges who are considered in that judgment?
Well, we do it in chambers. Each of us get the papers, and we consider it, and the junior judge normally goes to the senior judge and says, well, I've read the papers, are you ready, can we discuss it? And they make up their minds as to whether they should grant leave to appeal or not.
And where would the appeal be heard? By the Supreme Court of Appeal, or will it be taken back to the High Court?
They can decide. Either if it's a serious, especially a legal issue, then the SCA will do it. Otherwise, they'll send it back to the full bench.
Okay. No, thank you very much. My second question is in relation to a judgment that appears on page 10 of your questionnaire. Buota versus Buota.
I think it's on page,
I think it's easier if you go to page 10.
well, I'm not sure whether the pages are correctly numbered, but I know the judgment is on my page 5 of my questionnaire. That is the friendly sequestration issue.
Yes,
Yeah.
yes. In paragraph 12 of that judgment, you stated something that is quite correct, that the applications for sequestration, the court has the discretion to allow it. And even if the requirements for sequestration are met, the court can still reject the application. I've always wondered, what would be the circumstances that would lead to the court, even though the requirements are met, to actually not grant the application?
Well, for example, even if it's a friendly sequestration, because it is clear that father that has lent money to his son, claiming 1,000 rand, they come and they can show that they've complied with that requirements, but it is clear that the only reason for that is for the debtor to get released from his creditors. It's clear that they try to prevent the process to be followed. What would happen in such a case is you dismiss the application, the creditors would be entitled to issue summons and to get warrants of execution.
Thank you very much, TJ.
Thank you. Commissioner Nyambi.
Thank you, CJ. Good afternoon, Judge.
Good afternoon.
The last time you were here was April 2021.
That's correct. Yeah.
Even though it was a DJP position in Free State. Between then and now, something that is, because now it's the issue of SCA, and you are left with the 3.5 years, as has been explained. Between then, when we were available to be the DJP in Free State, and now, any particular outstanding thing that has happened that we have to seriously consider this time around compared to then when you appeared in the GSC?
Anything that happened?
Anything that is outstanding that was not considered then, that now we have to seriously consider so that we can...
Oh, I see. Well, I think it's a difference in the approach, because there was the issue of leadership in that division, where I've acted many times. And may I just say, is that in that leadership position, on a weekly basis when you are there, you have to look at all the files that are given to you for the next week. You've got to check each and every file to see how complicated the matters are and to whom to be issued. So I acted only as acting DJP since then, this last term for a while, a part of the last term. But nothing different happened except that I had the 2 stints at the SCA. There's nothing else that happened. A few judgments have been reported, but the position is the same. There was a leadership role. Here is a bit a different role because, it's not the leadership capacities that are so much so required at this stage, but whether you can fulfill the job as a Supreme Court of Appeal judge.
My last question. What is your summation of the state of transformation in the judiciary?
I think it's very good at this stage. If you look at the SCA, 55% of the judges, 54.5% of the judges are already female judges, and 45.5% are male judges. And I think it's over I've got the figures. The percentage of white versus black is also, I think there are 13% white males, 9% white females, that's 22%, and I think 77% are not white. So if you look at that, we've moved a long way from 1990 up until now. If you look at all the female justices that have been appointed at the various divisions, the Constitutional Court, the SCA, and also at the various local divisions, I think many strides have been made. And what I can say is if I'm appointed, for example, as a white male, it's not going to be a reverse gear of the transformation. It's not going to change because there are 3-4 vacancies. So I'm not going to be a stumbling block for transformation. In fact, it will show the diversity. Justice Matlanga has recently also written an article indicating that the diversity must be properly considered on appeal benches, and he referred to Sidney Kentridge and some other people as well in that regard.
Thank you, CJ.
Thank you. Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Judge Diffel. I'd just like to know, in your career as a judge so far, at different levels, have you had occasion to pen any minority judgments?
Have you ever?
Occasion to pen any minority judgments?
Yeah, I have. I think in 2 instances.
And what is your general view on minority judgments?
Well, if you're wrong, you're wrong. I accept the majority's decision, and all of us, like in the SCA and the Constitutional Court, we often disagree, and I accept the majority decision.
So you've only had 2 minority judgments that
Yeah,
you wrote?
yeah, I definitely. I can only remember the 2, and that was quite recently also.
In the SCA?
No.
While you were acting?
No. No, the minority judgments were in the High Court. In the High Court, not the SCA. The SCA, my judgment became part of the majority, if I may say so.
Thank you, Chief Justice.
Thank you, Commissioner Singh. I've noticed your hand, Commissioner Barnett, Commissioner Baloyi.
Thank you, CJ. Good afternoon, Judge. I want to go back to the concern about the time that you still have to serve on the bench, the 3.5 years odd. And it's a matter that I would like to get your comment about from a different perspective. You, in these 3.5 years, if you remained in your division, you will continue to be one of the senior judges, as I understand. I'm assuming that the division doesn't have many senior judges. So you would continue to be a senior judge. You would continue to provide leadership, support, and guidance to the more junior members of that bench. That is, if you remained where you are. And yet, if you went to the SCA, if you were to be appointed by the president to the SCA, in that 3.5 years, you will be a junior member for most of it.
Yeah, that's
now, let me finish.
Sorry.
Now, my concern comes from this, that aren't you going to contribute even better and more by retaining your senior position presently, where you sit, according to your judgments, most of the time you sit alone, and you're providing light on these important cases that you have referred us to, vis-a-vis going to the SCA, where you're going to necessarily be part of a bench and be a junior in that. Isn't the judiciary and the development of our law going to be better served by you completing that 3.5 years where you are today?
Madam Commissioner, the problem with such a question is that most of the judges that seek to go to the SCA are senior judges in their division. Whether you come from Kimberley, Bloemfontein, or Grahamstown, you are a senior judge. So what goes for me goes for all the others in the smaller divisions. But I agree with you that I can still give leadership I would be able to give leadership in the High Court. But on the other hand, I'm satisfied that I can also make valuable contributions in the SCA, which I've done. And the kind of work in the SCA is of such a different caliber as you would normally get in the High Court, where you sit in criminal trials, for example, or normal motion court matters, which are not, which can be done by junior people with great respect. So yes, you are right to a certain extent, but the issue will be the same for other people as well.
Can I just lastly say, I don't find the comparisons or references to other judges in the way that you're doing now to be helpful, because we are not discussing the circumstances of each appointment. I'm speaking specifically to you, being senior but with 3.5 years to go.
No, I understand that.
And coming from a particular division.
Yeah. No, I understand that, but you will also remember that in the last, I mean, there are many of my colleagues where I've got 12 years now. At least the JP has got more than me, and there's another judge that's got more time than myself. And some of the other judges are there for 10 years, for 8 years. So they're not junior judges of 1 or 2 years standing. So they are capable people that on their own can be regarded as senior judges at this stage. And I'm satisfied that that will not make so much of a huge difference. Although I've assisted for especially acting judges tremendously when they acted there, my other colleagues can do the same.
Thank you, CJ.
Thank you, Commissioner Baloyi. Commissioner Barnett.
Thank you, CJ. Good afternoon, Judge Kafu.
Good afternoon.
My question is about the principles involved in cost orders. So how should cost orders be dealt with on appeal? Does this differ when the litigation involves constitutional rights litigation? And then finally, how should a court of appeal deal with an appeal against a cost order? So cost-related things.
Yeah. Well, the BioWatch principle by the Constitutional Court is available in constitutional matters. Even if you're unsuccessful, the court is not going to give a judgment against you. And obviously, the appeal court is not always willing to deal with cost issues only, but and not dealing with the merits. But I could gather that it is possible where it is a clear case where the litigant has lost a constitutional issue, matter on a constitutional issue, and costs were granted against that person, that he might have a good chance to take that on appeal only, and that the Court of Appeal can deal with a cost order based on the BioWatch principle.
So when would the court interfere with the costs principle, cost?
Well, I suggest that the court can interfere.
I think the question is when will the court interfere with a cost order? And I think he's talking an appeal court. He confirms that that's the question he wants you to answer.
The question is a judgment from the High Court going to the SEA.
The question is, when will an appeal court interfere with a cost order made by a lower court?
Yeah, well, that's what I said, is that the court will seldom just interfere with a cost order if that is the only thing on appeal. Because it's very seldom that the Court of Appeal will deal with the cost only, but in a case where the constitutional issue was raised, the litigant lost his case but got a cost order against them, then surely the Court of Appeal would be entitled to say, well, we've got to follow BioWatch, and in terms thereof, the quota quo incorrectly made an order pertaining to costs, and that should be substituted with a proper order.
Sorry, if I can we just leave the constitutional aspect out of it now? Just a normal court of appeal and a cost order from a lower court. When would the court interfere with such a cost order? What are the conditions?
Mr. Barnard, I must say that as far as I'm concerned is that cost orders shall seldom be interfered with, because you've got to go to the merits, and if the merits are not on appeal, my view is that there would seldom be scope for a court of appeal to deal with cost orders granted by the lower court, if that is the only issue on appeal.
I don't want to belabor the point, it's my last thing, but what is important for me is you keep saying it won't really happen, or it won't often happen, or it will seldom happen. But the question is, when can it happen? When should a court interfere with such a cost?
Well, clearly, if the court has misdirected itself and on issues or exercised its discretion totally incorrectly, then the Court of Appeal would be entitled to do that.
Thank you, Judge. Thank you, Chief Justice.
Okay.
Thank you very much. We have come to the end of the interview. Thank you very much, Judge Dafu, for making yourself available for this interview. You are now excused.
Thank you very much, Chief Justice. I appreciate the opportunity to be here.
Thank you. Commissioners, I want to encourage commissioners as we go along with the interviewing of these candidates. I want to encourage commissioners not to ask questions when they have been covered. And maybe to consider also asking when it's really something they feel strongly about.
And also not to flog a dead horse.
Nobody must feel that they are being prevented from asking, but we just want to try and not delay too long. Okay. You can bring in the candidate. Commissioners on the virtual platform, are you there?
We are, Chief Justice.
Thank you very much. Thank you. Good afternoon, Judge Catherine Setlwane.
Good afternoon, Chief Justice.
How are you this afternoon?
Very well, thank you, but you can imagine, very nervous.
Well, I don't know what you say, I can imagine, because you are very used to that's it.
Yes, I've become a veteran at this, but it's always a daunting experience. I mean, there's a wealth of wisdom in this room.
Yeah.
Like I've said before.
Okay, now we will start. Thank you very much for availing yourself for consideration for appointment to the Supreme Court of Appeal. You already know the procedure here. I will ask you questions, and then the Deputy President of the Supreme Court of Appeal will ask you questions, and the Minister, and then commissioners will also ask you. We'll try by all means to bear in mind the selection criteria that we have adopted as a commission in asking you questions. So we are going to start. Your academic qualifications are BA, LLB, and LLM, is that right?
Yes, Chief Justice.
Yes,
Correct.
and you got them respectively from the University of Natal and Georgetown University.
Yes, my LLM from Georgetown University.
Yeah, the LLM is from Georgetown. And you started your pupillage, was it in the mid-90s or it was around 1996?
1995, 1996, yeah. I can't.
Yes.
Trying to
And you were appointed...
1996, you're quite right, yes.
96. You were appointed as a judge in 2010.
Yes, October 2010.
Yeah, so you have been a judge now for about 13 years?
Yes, 13 years, and I was an acting judge for about a year before that.
Yes. And you have acted in a number of courts. You have acted in the Labor Appeal Court, you have acted in the Competition Appeal Court, you have acted in the Constitutional Court, you have acted in the Supreme Court of Appeal.
Yes, Chief Justice.
I don't know whether you've acted in the Land Claims Court as well.
No, I didn't act in the land claims.
But all the others that I've mentioned,
Yes.
I'm right.
Yes, all the appellate courts I've acted in.
Yes.
You're quite right.
And I would imagine that you have been exposed to all these different branches of law in terms of the experience you gained through acting.
Yes, I'm very fortunate to have been invited to act in those courts and to have sat for some time in those courts.
Yes.
And I've had the opportunity to be exposed to areas of the law that extend beyond the law which we deal with in the High Court, I suppose.
Yes. In the Constitutional Court, were you there for 2 terms or more than 2 terms?
For 2 terms.
Yes. And in the Supreme Court of Appeal, how many stints have you had and how long were the stints?
I first acted in 2016 for 6 months, and I was invited. Thank you to Deputy President Petse, who's here today. I was invited again at the end of last year. So I've been there since the 1st of December, appointed on the 1st of December, and I will continue to sit till the end of this year.
Yes.
Yes.
Yes. And in all these courts in which you have acted, have you been able to produce reported judgments?
Yes, Chief Justice. I have produced in excess of, I think, 62, 63, it may be up to 65 reported judgments in all of these courts.
Yes. And the 2 acting stints that you have had in the Supreme Court of Appeal, how have you found acting in that court?
Oh, I've thoroughly enjoyed it. I've thoroughly enjoyed it. I enjoyed my first experience there back in 2016, and I've enjoyed this experience since the beginning of this year even more. It is an absolute pleasure to sit in the court. It is such an organized court. You know exactly what's required of you, you know, what your allocations are, what your tasks are. You learn from the senior judges in that court, which is really wonderful, you know, to kind of work having the guidance of the senior judges and the junior judges that have been there now for some time. You know, for them to guide you in the process. And they're wonderful people that serve in the Supreme Court of Appeal. Over this last year, I've made some friends and some very good friends. And, you know, I hope that I can actually be part of that court and to be able to make a contribution to that court. The collegiality is just unbelievable in that court. You know, you would think where one sits in appellate court and you are dealing with highly contentious areas of the law, and you have all of these differing views from members of the panel, but I haven't had any, you know, aggression. I never had any bad experiences with the judges there. if I wish to dissent in a judgment, or if I wish to write a minority judgment, or if I wish to basically bring my, sort of add my view to the scribe's judgment. So I haven't felt any resistance, and I feel that at the end of the day, we all work as a team with the guidance, of course, of the presiding judge. Yes.
Yes. And of course, when you were acting in the Constitutional Court, you would have had exposure to dealing with a lot of constitutional cases, is that right?
Yes. Some were constitutional, pure constitutional cases. Other matters were matters that dealt with important points of law.
Yes.
Yes.
Yes. Did you get a chance either while acting in the Constitutional Court or in the High Court or Supreme Court of Appeal or in any of the courts in which you have acted to deal with a case where you were required to decide whether legislation was inconsistent with the Constitution and therefore invalid?
Yes, I've dealt with one or two cases, a few cases actually,
Yes.
where we had to decide whether the legislation was inconsistent with the Constitution, and we declared it unconstitutional, or found that it wasn't constitutional. I think there was the McBride matter that I sat in. There was the case pertaining to the 2,000 to 4,000 residents in buildings downtown that were basically removed from their homes in the middle of the night by the police on the basis of a warrantless search. And we found that provision of the Police Act to be unconstitutional. There was the Contingency Fees Act. There was a constitutional challenge to that came before us some years ago. And we found that that provision wasn't unconstitutional.
Mm-hmm. Are you able to share with the commissioners what you look for when you consider whether legislation should be declared inconsistent with the Constitution and invalid? How you go about, what you look at, what you look for?
Okay. I think one needs to look at the provision that's being challenged, the impugned provision. One needs to interpret that provision, and one needs to interpret that provision purposefully in the context of the Act as a whole. One needs to interpret the right that is infringed. One needs to, given the lapse in the many of the years now, the Constitutional Court has basically given content to most of the rights in the Bill of Rights. So you look at the rights, you look at how it's been interpreted, and you don't just look at it literally for what it is and what it says in the Constitution, but when you're interpreting the rights in the Constitution, you must actually look at the whole value system of the Constitution. You must then, of course, look at the provision, the impugned provision, and see to the extent to which it infringes the right in the Constitution. And then one also has to then do a limitations analysis, and integral to the limitations analysis is the proportionality of the infringement and the reasonableness of the provision. One needs to look at the legislative purpose behind that legislative provision, and one also needs to look at whether it is the least restrictive means of actually achieving that legislative purpose. So it's an interpretive process, and then you've got to assess it against the constitutional right, and then you've got to do a limitations analysis. And of course, also, you've got to also look at all of this, like the Constitutional Court has said, through the prism of Section 39, one of the Constitution. And when interpreting legislation and developing the common law, one has to have regard to the spirit, purport, and objects of the Bill of Rights.
Thank you. There are two types of discretions. Do you want to share with the Commission if that is in law? Maybe there is a third one. But the common ones, I think there are two. Do you want to share with the commissioners what they are and what the differences are about them, or the legal significance of the differences between the two?
Okay. Well, I always get confused with the terminology here, so just forgive me if I get them wrong in terms of the terminology, but I know what they are.
Yeah.
So there's the narrow discretion, and there's a wide discretion. And I think that the distinction lies in the standard, or the distinction basically dictates the extent to which, or the standard of interference, basically, by an appellate court.
Thank you.
Do you wish for me
Are
to
you
go
done?
further? Well, if you want, insofar as the distinction.
Well, if your answer was not complete, you can complete it.
And I think it's important. There's very little scope for interference by an appellate court. Appellate court will seldom, basically, interfere with the exercise of a discretion, unless, if it's a narrow discretion, unless, you've got to look at whether the High Court basically exercised the decision judicially, or whether it was influenced by wrong principles, or an incorrect assessment of the facts, or for some other reason the decision is so unreasonable that it doesn't accord with understanding of the facts and the circumstances of the case as a whole. In relation to the wide discretion, the decision maker has a choice of options or variables, and the decision maker can choose from any of those options or variables. And a court can really only interfere with that choice if the option adopted by the High Court is at odds with the law. I mean, I think this is important because it's important for comity of the courts, it's important for finality of the judgments and for certainty, finality of the law and for certainty of the law. I think I'm finished now. Thank you.
Thank you. I will now give the opportunity to the Deputy President of the SCA.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Judge Katristetulwana.
Good afternoon, Deputy President Petse.
You have already told this commission that you acted at the SCA 2016, and you have been there again since the 1st of December 2022.
Yes.
And you have a handful of judgments in the SCA to cover those periods.
Yes, yes.
I had occasion to be part of your 3 previous interviews when you were interviewed for the position of the Constitutional Court, and your name ultimately featured in the list of names which were sent to the President in terms of Section 174, subsection 4A.
Yes, Deputy President.
And on those 3 occasions, although you were being interviewed for the position in the Constitutional Court, I raised everything with you which I thought, needed to be explored with you. You still recall that?
Yes, I recall very clearly. And thank you for raising those issues with me, so I could give some clarity on them. Yes.
Thank you. And my parting shot with you now is, unless, of course, you want to disagree with me, I may be wrong. If you were recommended for a position in the Court, which is the apex court, you should be equally up to the task, or even better, for the SCA, which is not the apex court.
Yes, sorry, I'm here to be recommended for the SCA right now. I'm a bit confused by the question, sorry. You are saying if I were recommended for the Constitutional Court?
No, what I'm putting to you, you were recommended for appointment in the Apex Court.
Yes, yes.
And the SCA is not the Apex Court.
Yes, yes.
And you are now vying for a position to grace the bench of the SCA.
Yes.
Can you think of any reason that would disqualify you from ascending to the bench of the SCA?
Judge Petse, I can't see why I shouldn't be recommended for this court. I think with my experience on the bench, 13 years being a high court judge, and my appellate experience, one hopes that the commissioners here today will basically recommend me for a position to the SCA. I would have applied earlier for the SCA, but I didn't feel that I was ready because I hadn't acted. I mean, there is a practice that you need to act for a fairly long time there before you can be recommended for appointment to that court. I am so happy, having returned to the SCA, I am so happy at the SCA that making application to be elevated to the Constitutional Court lies so far, far away from my mind right now. I feel like I've really found a place in the SCA where I could, where I'm satisfied and interested by the law that we are attempting to make in that court. And so there's no reason for me, to jump very quickly to try and apply for the Con Court. Again, I am very happy here. And I would like to stay here and gain experience and make my contribution to this court if I can, or if I may.
Okay, then that's your wish or desire, but do you think that you possess the requisite attributes
yes.
to serve in that court, given that it's a national appellate court?
Yes, Judge Petse, I think I have the necessary experience for the court. I think that I have the ability to write judgments at the level of which that court basically expects one to write. I think that I will fit in very well in that court. And I think that I can make a contribution to that court. Yes.
Thank you, Judge Catrice Tulane. Thank you, Chief Justice.
Thank you. Minister?
Thank you very much, Chief Justice. I've got no question except to say that I was also present in the last interview. Thank you.
Thank you.
Thank you, Minister.
Commissioner Nojesi?
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner Nojesi.
I'm just doing fairness to other candidates with these two questions. One, at the SCA, even at the Concord where you have acted, you sit as panels, as a panel, and in those panels, other members are expected to contribute, correct judgment, or make comments.
Yes, yes.
Is that acceptable?
Yes, they all do. They make substantive comments, and they make comments related to, syntax, grammar, all of those little things, yes.
Yes. And second, with regard to the role of presiding officers, do you regard presiding officers as one among equals or as sort of principals in the panels?
No, I think they are presiding judges, but they are one amongst equals. Yes.
Thank you.
Yes.
Thank you, Commissioner Nojesi. Commissioner Marumwaha.
Thank you very much, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner Marumaka.
I just want to ask you two questions. One, it's procedural, and the other one is more substantive.
Mm-hmm.
if you are sitting at the SCA and you are one of the two judges who receives an application for special leave to appeal and you dismiss that application, apart from the litigant appealing to the High Court, is there any procedure that they might utilize at the Supreme Court of Appeal? If there is, what is the procedure and what are the requirements?
Yes, I think if they are unhappy with the refusal of the leave to appeal by the Supreme Court of Appeal, then they have another bite at the cherry, and they are then allowed in terms of Section 17(2)(f), I think, of the Superior Courts Act, to basically seek a reconsideration, and that reconsideration will go to the President of the Supreme Court of Appeal, and the President will have to apply her mind to whether or not that application should be granted. Of course, you need to show that there are exceptional circumstances for a reconsideration, and I think there are judgments of the Constitutional Court, and one judgment in particular that I was involved in, which is the leashing judgment, which basically sets out the test that needs to be applied. But it's exceptional circumstances that have to be shown. You have to demonstrate exceptional circumstances.
No, certainly. Thank you very much. Another question would be a little bit unfair if you don't remember the facts, because it's one of the judgments that you wrote. I saw the judgment on your questionnaire, but just citing that you have written it, it's not here. But I'm hoping that you do remember. But if you don't remember, it's fine, because it's not a test, right? I'm raising that judgment because it's an important judgment, and you got it spot on. And it is in an area of law where I think the Supreme Court of Appeal has been found lacking on that. It's pension law, right? It was the withholding of retirement benefits. I'm not sure you read the Makate judgment.
Yes, I do remember the judgment. I think it dealt with, the court had to interpret Section 30N of the Pensions Fund Act.
Yes. The question I want to ask is this. When a panel is sitting and considering any matter, and there are cases that the Supreme Court of Appeal have actually decided upon, what leeway do those judges have to disregard? I'm not here. You did not do that, but I've seen other judges disregarding the same judge, the other judgments of the same court in the same area. Why do we see that happening from the Supreme Court of Appeal?
I think you can't just willy-nilly ignore previous decisions of the Supreme Court of Appeal. You can only interfere with you can only criticize those judgments or go against those judgments if those judgments are clearly wrong, and you have to then demonstrate why those judgments are clearly wrong.
Thank you very much, Judge. Thank you very much, TJ.
Thank you.
Thank you. Commissioner Steinberg.
Good afternoon, Judge.
Good afternoon, Ms. Steinberg.
You clearly have an old and deep and commendable interest in transformative jurisprudence. It's occupied your mind for many years. I'm interested in what would your advice be to High Court judges in particular about how we develop a more transformational jurisprudence in our country. See, it seems to me we focus more on the demographics of the judiciary, which is one obviously key aspect of transformation. But the other is the jurisprudence itself. We're looking for a jurisprudence that addresses socioeconomic inequality, racial and gender inequality, etc. What's your advice to judges in that regard?
Yeah. I think one has to eat, sleep, live the Constitution. And, I'm of the view that the Constitution infuses all areas of the law. So as a High Court judge, don't fall into the habit of compartmentalizing cases and saying, oh God, this is a pure contract law case, and the Constitution has no impact on that. So it's very important that you do your best, both in applying the law, both in probing issues that come up for determination. And when you're applying your mind to writing the judgment, to ensure that at the end of the day, there's this recognition that there's this broader piece of legislation that basically suffuses everything related to the law. And so I think it's very important at that early stage in the determination, well, in a life of a high court judge, to actually start to have a feel, for the Constitution. And I mean, it's wonderful. When at the High Court, and I'm talking about a few years back, we had a tea club. And most of my colleagues from that tea club have now been elevated to the SCA or to the Constitutional Court. But we had such stimulating discussions in that tea club, and they weren't just about the narrow issues in the case, but they were about the broader constitutional impact that these cases would have. So I think one needs to start thinking beyond just the narrow issues that you're dealing with in the case. Clearly, you can't visit issues that have not been raised and are not issuably raised in a matter. But one needs to kind of have a feel for the Constitution, and one needs to infuse the value system of that Constitution into your job as a judge, I think, and central to that task of being a judge is judgment writing. And I think one has this broader knowledge and understanding of the law and how the constitutional basically plays into that, one can then produce better judgments. And it's important to have a substantive understanding of the Constitution. I mean, I think that really it plays an important role when one is dealing with cases relating to socio-economic rights. And so it's not just the formal application of the Constitution and what it says, but have a substantive application. How can one use the law to change the lives or change society in a way? You'll obviously do it incrementally, small steps. You don't always get the right cases, to make this great big impact. But as you rise in the judiciary, those opportunities will come your way, I suppose.
Thank you.
Thank you, Ms. Tambo.
Could I just follow up on this discussion, Chief Justice?
I'm sorry, you are done, Commissioner Standback. Okay, you want a follow-up?
Yes.
Yeah, okay.
Justice Kathrisa Tulan, I mean, this for me is very interesting, this idea that the Constitution infuses everything, particularly because now you're going to go to the Supreme Court of, well, if you are recommended, I shouldn't run ahead.
One hopes that I am, Mr. Nguke Toby.
No, I should not run ahead of myself. I'm just one of 23 or 22. I mean, so, because I think in the Supreme Court of Appeal, we can ask you about your judicial philosophy, because you are going to be laying principles of general application to be followed by the High Court judges. And you've said to us, well, the Constitution infuses everything, but the one critical area of the law that the Constitution is not infusing is contract and property and delict. And you can see the two divergent streams of law, one being developed by the Constitutional Court and another being developed by the Supreme Court of Appeal. And you can see resistance. In fact, this is not me saying that, it's Justice Froneman who says that often the Supreme Court of Appeal explicitly rejects constitutional direction from the Constitutional Court on contract. So I want you to give us something actually tangible about what you mean. And here, I think the last iteration of the conflict is Bidika, and the judgment by Justice Froneman, which is about, well, good faith, are you for it or against it? Constitutionalism, are you for it or against it? So what, in fact, are the judicial tools to infuse the Constitution so that it's foundational to contract? Because right now, it's actually the common law that is foundational to contract.
Yes.
Everywhere you go, the judges will repeatedly give you the mantra back. You go there to argue a constitutional case, what is the answer from the judges? No, pacta servanda sunt. I know, that's why I'm arguing the Constitution. So it's very nice to go to conferences and to say the Constitution underlies everything. But our experiences day in and day out is that judges almost, their natural reflex is the common law.
Yes, but I think in the Biedica judgment, Judge Taron had basically said that Ubuntu plays an important role in the law of contract. And again, it's for the Constitutional Court to give us to provide that normative framework on how we actually infuse areas like contract and delict, etc., with the value system of the Constitution. So, I mean, it's also difficult. I mean, one has the habit of falling back on common law principles, but to the extent that the common law is lacking, one needs to basically see how one can develop it. I mean, in the context of, I'm just thinking in the context of delict.
No, let's just stick to contract for now, because that's a more tangible thing.
Yes.
It's not as abstract as delict.
Yes, yes.
I need to get a clear example of what you mean by this infusion, because my own experience is that judges inevitably take you back to the common law.
Yeah, yeah. I mean, I think if you look at some of those cases relating to National Credit Act and contracts between banks and homeowners, you know, I mean, I think.
No, but they will say that those are already developed by statute. I'm looking for judicial development.
Yes. Yeah, I mean, I just think that it's one, of course, there's a contract, and, you know, there are the terms of the contract, there's agreement between the parties in relation to what those terms are, and the relationship is basically guided by those terms in the agreement. But, you know, there may be instances, I'm just thinking about many years ago when I was still in practice at the bar, and I think I was just a very, very junior advocate. I remember there was a private school that basically expelled a student for some flimsy reason. And I remember going into urgent court and arguing this matter, and you know, I was raising all of these constitutional principles that she has a right to education, and I was told, no. You know, the contract says that if you have misbehaved in this particular manner, then you will be expelled instantly. And I think one could look at this young girl who was 17 years old. She was about to write her matric exam, and here was a private school that basically expelled her on the eve of her writing this exam. And the court should have there taken into account the fact that she was under 18 years old, that she had certain rights, and by the contract, by the terms of the contract, basically stating that she could be expelled for this flimsy reason, that contract was then in contravention of an important right for a young person, the right to education. I'm just thinking how practically you could actually apply provisions in the Bill of Rights.
Yeah, so the one way of doing it then is where contract infringes a right in the Bill of Rights, it should be struck down on that basis.
Well, I suppose, yeah, you could find that I don't know whether it's going against public policy, but certainly there is there would be an infringement of a right, an important right.
With public policy is that that's the common law.
Yeah, that is certainly the common law.
But I'm talking about the Constitution.
Yeah, so I'm saying in the case where this young person was expelled from school for this very flimsy reason, and even if it wasn't so flimsy, one should have had regard to that very important right and what it means to a young person and that young person's livelihood going forward. So perhaps, you know, the court could have taken that into account before finding that the contract prevails.
This is the last follow-up on this. And because I thought there's a promising start where contract infringes a right in the Bill of Rights, then that's the basis on which it can be invalidated.
Yes, I think you can invalidate it. Yes, I do. I believe you can invalidate it. And the court ought to have given consideration to that.
Thank you, Chief Justice.
Thank you. Commissioner Klaba.
No, thank you very much, and good afternoon, Judge Setilwane.
Good afternoon, Commissioner.
Thank you very much. I've been looking at the comments of the law bodies, and they all wrote glowingly about you.
And you have been before this commission several times, and on one occasion, you were recommended. Besides me asking you a probing question, what do you want to tell us that you did not tell us in the last occasions?
The last 4 times.
The last 4 times you were before us. Thanks.
I suppose in the last 4 times that I was here, I was applying for the Constitutional Court, and there was a different test. And I suppose now it's the Supreme Court of Appeal. And I think, again, I think I've sufficiently matured in the judiciary to be elevated to that court. And I strongly, hope that I would be. I don't know what you mean by what should I tell you that I haven't told you before. I think I've been a veteran, and I have been quizzed on virtually everything relating to my career from its inception. If there's something specific.
Nothing. Good luck.
Thank you. Thank you, sir. Thank you, sir.
Thank you, Commissioner Trevor. Commissioner Lucas.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Commissioner
And,
Lucas.
It's nice seeing you again.
Lovely seeing you too.
Yes, you are one of the faces that is quite becoming a usual face here. And I should say I always enjoy the way you respond to the probe of the commissioners.
Thank you, Commissioner.
Yeah, some of the elements of the question that I want to ask you have been asked before, because one of the responses that you gave earlier is that in whatever you do as the judiciary, you want to make sure that we give effect to the Constitution and possibly strive for a more equal society. That is what I will add, but also to address issues of discrimination. I've noticed that you have been actually bringing the case to court on issues of same-sex marriages. But in hindsight, if you think about it, in terms of the achievements, after that they've been now enacted, and also in our engagement with many people, we still find that there is a lot of discrimination. And even in the process of enacting the hate speech bill, one of the groupings that is really experiencing problems is the LGBTIQA. So I was just thinking, in your own imagination, and particularly since the religious community is also still not very comfortable with this specific issue, in your own, are you convinced that at the time it was the correct step and the correct decision? And if you think now about it, what more can we do to make issues of LGBTIQA acceptable in some of the groupings that we interact with? Thank you.
Yes, Commissioner, thank you very much for the question. I mean, I think that, I think it was 2001, 2002, that the Constitutional Court decided that matter. And yes, I was one of the 2 counsel that were involved in the matter. It was, I was led by Danny Berger, SC. I think it was an important time, given the progression of the rights of the LGBT community, to basically, for the court to basically deal with the question of marital rights of LGBT people, and whether the legislation and the common law did not, in fact, infringe upon their rights and treat them differently. The legislature, through direction from the Constitutional Court, basically enacted the Civil Union Bill that went broader than just the rights of the LGBT community. But it was the right time, and we made, South Africa being a little country so far south, we made a big impression with that judgment, and that judgment was looked at by the courts and the highest courts in the lands of various countries that were also thereafter, and many years thereafter, had to look at the the question of whether the right to marriage should be given to members of the LGBT community. So that piece of legislation was very important. I think without the challenge to the Marriage Act and the common law, we wouldn't have had that piece of legislation. But one needs to still accept and recognize that members of the LGBT community are basically victimized every day. They are a minority group, and they, particularly transgender individuals, suffer at the hands of broader society in the sense that they are subject to violence in the areas that they live, in the schools that they attend. There needs to be a whole mindset change. So our constitution is so forward-looking, our legislation is so forward-looking, but society has to also move forward with the changes in the law. So I think it's important that society be educated, and that education needs to happen from the time that we're very young. The education needs to happen particularly relating to gender-based violence, violence against members of the LGBT community. That education needs to happen at primary school level. And in time, you'll find you'll have a population that is more open to minority groups, such as members of the LGBT community, to basically live their lives free of violence and discrimination. Thank you.
Thank you, Commissioner Lucas. Commissioner Poswa Leratoli.
Thank you, CJ. Judge Katri Tilwani, I understand that you are saying you are now focused on going to the Supreme Court of Appeals, but I just find it difficult to understand that you have applied 4 times to go to the Constitutional Court and that now you are ready and willing to serve in the Supreme Court of Appeals. I'm not too sure how much committed you would be to do so, and whether it is not just a matter of it being a last resort.
Commissioner, thank you very much for your question. I think if I had the opportunity previously to apply to the Supreme Court of Appeal, I would have done so. And whenever I applied for the Constitutional Court, the thing that always worried me is that I would have liked to have gone through the Supreme Court of Appeal first. And now that I've been invited back to the Supreme Court of Appeal and I've amassed sufficient experience as a judge of that court in the last year and the previous time that I applied. Remember, the last time I was at the Supreme Court of Appeal was for a very short period of 6 months. And I truly believe that the Supreme Court is now the place for me. I have no ambitions right now to even consider going to the Constitutional Court. I would really like to get experience at the Supreme Court of Appeal, and I would have applied to that court if the situation was different and the path to applying was clearer, I think.
One more question, Chief Justice. So how important is judicial temperament in the dispensation of justice? How important is it?
Yeah, I think judicial temperament is a very important criteria. I have been criticized by this body in the past for not having the requisite temperament. I would like to state unequivocally that I do have the temperament for being a judge. There were certain errors that were made in the past. One must remember that Johannesburg court is a very, very, very busy court. And as a judge in that court, you really have to be on top of your game. You have to be fully prepared for the hearings. You have to be able to, as a judge, streamline the issues in a sense, cut to the chase because you have so limited court time available to you. So very often, counsel think that they basically must set the pace of the hearing. And they think that because you're a junior judge or you're a women judge, they could set the pace. But very often, judges have to turn the tables and we have to say that this is how I see the matter, these are the issues, please address me. And if I'm wrong, tell me why I'm wrong. So I think that the court community, they see me as being a firm judge, but they also see me as a very fair judge. I do my best to give counsel every opportunity to basically argue their case fully, and I will then interrogate the issues with counsel, ask them the relevant questions, and in response, I expect them to persuade me on the merits of their case.
Thank you.
Thank you, Commissioner.
Thank you. I didn't see any hands from the commissioners on the virtual platform. I think we have come to the end of this interview. Thank you very much, Judge Catherine Setlwane, for availing yourself once again. You are now excused.
Thank you very much, Chief Justice.
Thank you.
Thank you.
Good afternoon, Commissioners.
Good afternoon, Judge Huele. How are you this afternoon?
I am fine, Chief Justice.
You are ready for us?
Yes, I am, Chief
Yes,
Justice.
no, that's good to hear. Thank you very much for availing yourself for consideration for appointment to the Supreme Court of Appeal. I am going to ask you some questions, and after that I will allow the Deputy President of the SCA to ask questions, and the Minister, and any other commissioner who wishes to put questions to you. In asking our questions, we will be seeking to get information that will assist us to see how you fare in terms of the selection criteria that this body has adopted in respect of judicial appointments. We will be seeking to ensure that while we may be robust in asking you questions, we will show courtesy and respect. You are ready for the first question?
Yes, Chief Justice.
Okay, all right. You possess or hold a BProc degree, an LLB, and an LLM, is that correct?
That is correct, Chief Justice.
And you got the BProc and LLB from the University of the North during those years?
That is correct, Chief Justice.
Yeah. And you got your LLM from UNISA?
My LLM and the old LLB in the olden days, it was a separate degree, unlike now, from UNISA.
Oh, the LLB you also got from UNISA?
Yes.
Oh, okay. Was your LLM a coursework LLM or a dissertation LLM?
It was a coursework.
Okay. And what branches of law were covered by the papers that you did?
Constitutional interpretation, advanced law of evidence, and advanced law in criminal law. And the last one was winding up insolvency and estate. There were 4.
Okay. Instead of your, in the case of your entry into the legal profession, did you start as a prosecutor?
Indeed, Chief Justice.
And you moved up to being a magistrate and a senior magistrate, is that right?
Indeed, Chief Justice.
And you also became a regional court magistrate.
Indeed, Chief Justice, although I didn't stay long there in that position, because at the same time, there was that course that was structured to fast-track women to the judiciary. I was fortunate to be nominated to attend one, so at the same time, during that time, I attended the course, and I was successful, and after that, I was called to act, and I went to act in the High Court.
Yes. Did you start acting in the High Court in 2018? No,
No, I think it's
2009? Or 2008?
Yes, I think it's
2008, I think.
Yes, 2008, because my appointment, if I'm not mistaken, I'll check it, was 2009.
November 2009?
Yes.
Yes. So you have been a judge for about, what, 14 years?
No, more than 15 years for now, because my 15 year was end May, because they also included, when they calculate my service, they included the fact that I acted continuously up until I was appointed.
Yes. Okay. You were initially appointed to the Northwest Division of the High Court.
Indeed, Chief Justice.
But recently you went to the Mpumalanga Division, is that right?
Indeed, Chief Justice.
Did you relocate completely, or you just wanted to work in Mpumalanga but retain your home in Northwest?
I retained my home, but I wanted to relocate. Unfortunately, whilst I was still looking for accommodation, COVID hit us, and then I couldn't get accommodation at that particular time. And I don't know whether I should say it's an unfortunate situation also. During that particular time, during the COVID era, I was called at the SCA, and then I couldn't also not get time to get full residential accommodation. I'm only back now, and property there is expensive. I'm still looking for it.
You have acted as a deputy judge president in Mpumalanga.
Indeed, Chief Justice.
How many acting stints have you had as acting deputy judge president?
I had 2 in Mpumalanga and 1 whilst I was still in Northwest.
Yes. Okay. How did you find the leadership role?
It was interesting, demanding at a higher level because now I was in the High Court. But if you look at my track record, I had been in the leadership role since my early stage.
Yes.
I was appointed a prosecutor, and immediately after 2 years, I was elevated to the bench. Within 1 year, I was requested to head a magistrate office. So I also went to Appington to head the magistrate office in Appington. So it was a good experience, challenging, but I didn't find it so difficult because I had previous experience at the lower court.
Yes. And how many acting stints have you had in the Supreme Court of Appeal?
If we calculate it, I think it's 5 terms because I acted for a complete year, 12 months, and then I was recalled again for 4 months.
Yeah.
From June to September, 4 months. That's another term.
Yes. And how did you find acting in the Supreme Court of Appeal, coming from what are not considered big divisions?
It is on a different level because the matters there are dealing with issues that are intricate. But at the same time, it is an empowering situation because unlike in the High Court, in most of the time you sit alone, decide matters alone, but whilst you are at the Appellate division, you sit in panels. So it is enriching to oneself because you have the benefit of the minds of other judges who mostly are even senior to you, and at least it's enriching. You get to know or you get to adapt very quickly. So I think it was okay, but when I was acting, it was during the COVID era. We did not have the benefit of like walking into a senior's office or a colleague office to bounce your idea because of COVID. And we did not go to the tea room because also a tea room situation also helps. A lot of the Supreme Court judges worked from home, so there were few. So one has to duck and dive to learn the ropes alone. But because I adapt quickly, I managed. Thank you.
Now, while you were in the Northwest Division, also in Mpumalanga Division, did you get a chance to deal with a matter where the constitutional validity of legislation was challenged?
Yes, but not where I was supposed to have declared it unconstitutional. There were other issues around the Constitution, but not where I was supposed to declare it unconstitutional.
Yes. And in the Supreme Court of Appeal, have you had a chance to deal with such matters?
No.
Yes. Okay. Now, there are two types of discretion in law. Are you familiar with them? And if you are, what is the legal significance between the two?
I think they are the narrow discretion and the wider discretion. If you are on an appeal level, when you find a matter where the issue of discretion comes in, you have to check whether it was a discretion in the narrow sense or in a wider sense. Then, if it is in the narrow sense, then on an appellate division or when sitting as an appeal, you will basically check whether that exercise of discretion was done judicially or not. And the wider discretion, it's more, the test there is more stringent, because then you will have to check whether whatever discretion was exercised is at odds with the law. Thank you.
I will now give the Deputy President of the Supreme Court of Appeal an opportunity to put questions to you.
Thank you, Chief Justice. Good afternoon, Judge Kwale.
Good afternoon, Deputy President.
In your questionnaire, I want to take you through to paragraph 16.5. You listed 3 reserved judgments. What is the status of those judgments?
I have, at the present moment, delivered all of them. I'll give you the dates, but if you can also check the comments from the General Council of Bar, they have already picked up that of the 3 when they made the comments, I had already delivered 1. But I'm going to update you in terms of the dates. The Matata...
Well, the answer, sorry to interrupt you, Judge Kwale, the answer is sufficient.
Okay, thank you.
So your last acting stint at the SCA was in?
September, I'm sorry if I'm interrupting.
August, September 2022. 22, yes.
Yes.
And you have not been to the Supreme Court of Appeal ever since?
Indeed, Deputy President.
A year ago, you appeared before the JSC, and the proposition that I put to you was that you are not ready to ascend to the bench of the SCA, and that more acting stints would help you perfect your judgment writing skills. But you were not interested in that invitation in the sense that you indicated that you were ready a year ago already.
Indeed, Deputy Chief Justice, I said that.
And what happened between then and now, when you have not had the opportunity to go and act at the SCA again, which makes you believe that you've got what it takes to be a member of that court, bearing in mind that it is a national appellate court which, amongst other things, must give guidance to the High Court insofar as the state of the law is concerned.
Thank you. I was fortunate to be allocated special motions, special trials, and appeals by the JP, the former JP, and the current JP. I think they were trying to tap on the experience that I had when I was coming from the SCA. The special motions are those cases where, in most of the time, the papers filed are voluminous, the issues are intricate, and or where the JP is of the view that the issues are designed to create a precedent in the division. And our division is a very small division. We have few permanent judges. So we operate mostly with fairly recently appointed judges and mostly with acting judges. The upshot of this is that as a senior judge, or as a presider, if I may call that, in those cases, you do more work to be able to steer the issues in those special motions, special trials. Last week I was doing a special appeal. When you sit with them, in addition to that, you also assist them, the junior, in writing their judgment. You oversee them. In fact, you oversee them. So the experience that I had in the SCA made me to manage to do that, but at the same time when I was overseeing their judgment, I further honed my skills. The other thing that may count in my favor is that I kept on following up on matters that I dealt with at the SCA, or where I was the scribe, or where I was just a panel member that went to the CC to try and keep abreast with the developments of the law. I can mention 1 or 2, the Minister of Water and Sanitation and others versus Casper. It went to the CC. Fortunately, our decision was upheld. Another one is RISC Street One-Stop versus versus Engine. That one also went to the Concord, but it was overturned. The other one is the Independent Community Pharmacy Association versus Clicks. There was a split majority. It also went to the Concord. There was a split majority. The minority unfortunately agreed with our decision. And the majority, so the majority overturned us. I am aware of another one, B versus B, but I think the judgment is not yet out, so I can't say anything about that one. And besides that, I also, time and again, when I had chance to look at the judgment in the SCA, I did that so that I keep abreast with the developments of the law.
Thank you. I'll propose to put to you what the major difficulty that the presiders had with the sort of judgments that you produced at the SCA, that they were not concise and underpinned by linear reasoning, focusing on material facts only, and that a lot of work had to be done to produce the final product. What's your response to that?
I'm going to respond. Firstly, I respect that view, but I have two fundamental flaws with the view. The first one is that this view only erupts during the interviews, because no presider ever approached me to complain about my judgments during my acting stint. The second is that the criticism is couched in general terms. There are no specifics provided in respect of which judgments are they, and there are no supporting materials to that. Unfortunately, general comments with no specifics are normally aimed at just breaking a person and not building one. Because if the specifics are provided, those specifics will guide you where your flaws are, so that you can be a better person tomorrow. But having said that, the first part of my answer is that it remains the same as last year. I do not agree with the views as so expressed, because no judgment that I wrote were ever taken from me by the presiders. No presider ever suspected, or not suspected, suggested that a colleague or on a panel should co-write with me. No member of the panel or the presider himself insisted on writing a concurring judgment because of my inability in writing. I'm talking about this because all of these are the trends that we made at the SCA across if your judgment are not as scholarly as they normally say in this SCA. But I have to also emphasize that writing a judgment is a lifelong learning experience. Even retired constitutional court judges, when they train us writing judgments, they always say that your first judgment will not always be the same as your last judgment because it keeps on changing as you fine-tune it. But it even becomes worse when you are at the Supreme Court or a court like the Supreme Court because there, your judgments, you are not sitting alone there. You're sitting with other members of the court. So the judgment is not yours. The judgment is a concocted effort of all the colleagues with their inputs. As and when they make inputs, you accept them. And maybe because, I'm just worried because this issue comes back for the second time. I just hope you are going to give me time to deal with it. I have to give an example. In one of the judgments that I wrote regarding the issues of servitude, in my first draft, I included the principle that we normally call the civiliter modo principle, which I applied to the facts. Now, the presider, when I handed in the first draft, he suggested that I should take everything that related to that. Although I felt strongly against that, but I then said, he's a senior, I think he knows better than me, I agreed. But here is what happened. When normally after the inputs of other colleagues, at the SCA, there is what we called a conferencing. We conference around the judgment, meaning we finally look at it, the final little, you use a fine-tooth comb to just check whether there is anything, but we are all together. So one of the senior judges, whom I regard as a specialist in servitude, was more worried about the fact that I did not include the civiliter modo principles, and he wanted to, to get chance to add that. But fortunately, because I had already done that, but because I was told to take them out, I then said, no, don't worry, look at what I initially said around that. He did that, and after I did that, I reinserted them into the judgment. But I'm trying to say that your first draft to not look the same as the last draft, it is not a surprising phenomenon. And I'm also trying to say that it is not true that my judgment were just hopeless. You always have to try and accommodate the inputs of the others. But assuming that the report that I get now, which is not written, And again, for me to lay this matter to rest, I want to say the following. It is important to have regard to the comments that were made by GCB this time. And we don't forget that GCB is one of the reputable legal body which consists of senior council members in it. They demonstrated that they took these interviews seriously, because what they did, on my part, they wrote comprehensive comments about each and every question that is supposed to be answered in the questionnaire. But of particular importance and relevance to the issue at hand is that they also demonstrated that they read my judgments, not only those ones that I have attached, but my judgments on SAFLI when preparing their comments. But again, as I've already indicated, more importantly, that they also read the judgments that I wrote after I acted at the SCA. But they say the following.
Do you still have more to say?
Yes, Chief Justice, I allow indulgence. This is the main issue, I think, that is on the table.
Yeah.
Yes. The candidate in paragraph 9.1, the candidate has produced well-structured and clearly written judgment penned in English. And in one of the paragraphs, they also said, they randomly picked my judgments. And I can also give credit to the comments that were made by LSSA, the Law Society of South Africa. Because there they say, in one of their judgments, her numerous judgments are well written and incisive. I think by choosing the word, and they said numerous, it means that they not only look at the SCA judgment, but those that I wrote at the High Court as well. But in my view, the word incisive, it's very important. And when I looked at the dictionary word of incisive, it says it means intelligently, analytically, and clear thinking, which is contrary to the views. But if we relate that definition to the action of a person, in particular in writing, it means that the ability to express what you intend clearly and quickly and directly. I am of the view that the selection of these words is instructive. I do not think that they just chose to include these sentences without having read my judgment. Thank you.
Thank you, Judge Kwela. But you would accept that the GCB would have had a recourse only to the final judgment that was delivered by the court.
I'm not sure whether I should answer because I saw, okay, sorry. The final judgment, if I understand you, pardon me if I don't understand you, by the court or by myself, yes. The final judgments, I indicated that they not only looked at the SCA judgment, I said they also looked at the judgment that I produced alone. Yes, they look at that, my final product. And as far as the SCA judgments are concerned, yes, they did look at the final product. But as I said, the final product might not even look like the first one, which is normal. The first draft that you made, because you make room for inputs of other judges.
And therein lies the rub, because if you accept, as you do, that the final judgment bears little resemblance to what was initially produced by you before the inputs of the other members of the panel.
Okay, if I may answer, I did not use the word little resemblance. I said it will not look exactly the same. So the word little has another meaning.
Thank you. Let's go to paragraph 16.1 of the questionnaire. It asks you to list judgments that you consider as significant and why. And you have listed those judgments on pages, paginated page 16, 17, 18, 19, 20. And I've had a look at those judgments in preparation for this interview. And in my view, they do not appear to have any precedential value. No new principle, no departure from an established principle, resolving, uncontentious issues, well precedented. What's your response to the proposition that I'm putting to you?
Deputy President, I respectfully respect your view, and that is your view. It will remain your view. But if we go back to the very same paragraph that you referred me to, paragraph 16.1, I'm going to repeat. It says, list the cases where you have written the judgment which you, meaning myself, it's relative, which you regard as being the most significant. Not necessarily setting precedent, but significant. And you have to, to state the reason.
Yes.
In all those judgments, I summarize what they are and why I personally regard them as significant. There's no one that I did not give reasons. If I can go to the annexure. The first one, Leon Geraldine versus Leakey. I said the matter, its significance because it demonstrates that sexual intercourse by an adult with a child will not be tolerated irrespective of whether the perpetrator is a female person. And the custodial sentence was confirmed by this judgment, was endorsed. That is my personal view, but another view which might add on what I said is that this matter has been reported. If it is reported, it means it meets the characteristics that you have just enumerated, or one of them, Deputy President. The Sajwa matter also, previously I also indicated that it went to the Supreme Court of Appeal, I think, on petition. It even went up to the Concord and it was confirmed. But there I also, my view was that it is important because it demonstrated that where there were two distinct decisions which remains valid until set aside, they will remain valid until set aside, and one, you can declare one and not the other. And on this one, when I dealt with this matter, I struggled to get a case similar to that one. In my view, even if it is not reported, it was very significant and it could have been a precedent setting. Bride, daughter as well, I'm not sure whether I should go one by one, but the reasons are there.
Yeah, well, you
Maybe
can,
to same time.
You can work on the basis that the commissioners are familiar with
They
your
read,
material.
they read.
Yeah.
Thank you so much.
I hope you do appreciate, Judge Hoyle, that I'm here to represent the interests of the court. And my involvement here is not about me or you.
I don't understand, Deputy President. Maybe you can elaborate further.
That I'm representing the SCA.
Yes, that I know.
Yes.
Yes.
And I'm duty-bound to put to all the candidates the difficulties that colleagues at the SCA had with each one of the candidates that will be interviewed during the session.
I fully appreciate and I know that because I'm not coming to the interviews for the first time.
Thank you.
Yes.
We'll then leave it on that note. Thank you, Judge Wele, and
Thank you,
Chief Justice.
Deputy President.
Thank you, Minister. No questions. Commissioner Nochesi, and then it will be Commissioner Baloyi. Oh, I'm sorry.
Thank you.
I'm sorry. Commissioner Marmohai. Before Nochesi.
Thank you very much, Chief Justice. Good afternoon, Judge Kwale.
Good afternoon, Commissioner.
I have two questions for you. The first one is, assuming that you are successful and you are at the SCA, and you happen to be one of the two judges that considers an application for special leave to appeal, and you find that you allow the matter to, you uphold the appeal, but you say, look, maybe it was a matter that can actually be dealt with by the full court. And then you say, no, we are not going to deal with it as the SCA, and we are going to take it back to the full court. Perhaps maybe the appeal was from the single judge sitting at the High Court. Under those circumstances, when the parties are going back to the High Court, given that there's a specific rule that deals with security of costs at the High Court, is the person who is successful at the SCA under those circumstances bound to pay security for costs? I'm not sure if you are with me.
Security for cost for the matter that has been at the
Yes, for the appeal that has been granted by the SCA. But the SCA has said, look, this appeal should be dealt with by the full court of the High Court.
Yeah, maybe I need more clarification because
Let me try to clarify
initially-
it. Let me try to clarify
Okay,
it.
yeah.
You have a judgment of a single judge in the High Court. Let's say maybe the single judge dismisses leave to appeal. Then the party who lost appeals or makes an application for special leave to appeal to the Supreme Court of Appeal to be allowed to appeal that decision. And the Supreme Court of Appeal says, yes, you can do that, but we are not going to consider it. Go back to the High Court. So normally, when you appeal from the single court to the full court, there is a provision that says you need to pay security for costs.
That
So
is where
what I want to understand is, when the judgment comes from the SCA, is there an obligation to pay security for costs?
In my view, I don't think so because, and that is where we couldn't get each other because I was going to say, remember before it goes there, security of course will have been paid. Yes, so when it comes back, I don't think there's an obligation as such. That's my view.
All right. No, thank you very much, Judge Kwele. The second question that I have is, and I think, look, I've read your judgment since from your days in Mafikeng to now in Mpumalanga. I think you write well. That is just my view. I think you do write well, contrary to some of the judges who express concerns at the SCA. I think your judgments are well written. That is just my view on that.
Thank you very much. It will make me feel better.
You contributed to two judgments in the SCA. The one is the ACAS matter. I'm not sure if I'm pronouncing it correctly. Yes. And the other one is B versus B. Both of them were maintenance issues. I just want to talk to you about the B versus B matter, where you enjoyed the majority. I mean, you wrote a unanimous judgment in that court. Basically, the facts were, or part of the facts were, you were dealing with an NCA, A and C. And on the other hand, there was an agreement. I'm particularly interested in paragraph. I know you may not have the judgment with you now, but I just want to make a point because this is not necessarily a test. In one of the paragraphs, you state that the ANC is by no means a contract. I was perhaps maybe I did not understand the context of that, and it's a pity that you don't have that in front of you. I just want to understand your understanding of an anti-nuptial contract and how an anti-nuptial contract should regulate the marriage in the context where there is an alternative or another agreement that the parties have actually signed, because that was the main issue in this judgment. Which contract becomes, or which document becomes an important document for the regulation of the parties' matrimonial property system?
Expressing my view, not necessarily, but I will look at which sentence were you saying. I'm not sure whether we say an ANC.
It's in paragraph 8.
Paragraph 8. It's not a contract. Let me just check the context. Is it B versus B?
Yes, B versus B.
Yes.
Paragraph 8, line number 3 from the top. The second sentence in that paragraph. It contains footnote 3.
Oh, footnote 3.
Yeah,
are you saying paragraph 8, which start with it is instructive?
Yes.
And then line number 3.
Line number 3, sentence number 2, which starts with regarded in this light.
Sorry. Regarded in this slide, the NC is by no means a contract. We refer to LOSA, South African law. I cannot remember well why we wrote it like that, but maybe it was in the context of
Or perhaps let me assist you. Is the ANC a contract? Let's start there.
It is because it regulates the what.
No, thank you very much. We can leave it at that.
Oh,
Thank you very much,
sorry,
CJ.
sorry.
Thank you. Commissioner Nochesi.
Thank you, CJ. That mine should have been a follow-up to the discussion between you and the Deputy Judge President. Firstly, I'm troubled about the fact that there are these presiding officers. Do you know who are they?
Pardon?
I'm troubled by the fact that reference is made to some presiding officers who suggest that your writing is not up to standard. Do you know who are the presiding officers that makes those remarks?
That is the point, because when I talk about specifics, amongst others, I didn't want to prolong the issues. Amongst others, and that is why I said which judgments. I don't have them now. Even previously, I don't have the name of the presiders, and in my view, if they are there, I don't think they are all, if ever they are there, because I receive praises from many of them. Yes.
And now, I asked the question.
And it doesn't assist me, because even for preparation, how do you prepare when you don't have specifics?
Okay, no, it's fine, that's the answer. Now, I asked you the question that I have asked other candidates. At the SCA, you sit as panel, that is as a panel, and one would be assigned as a scribe. Is it something unusual or unexpected that other members of the panel would contribute to the judgment that have been produced by the scribe, would comment and contribute in that judgment? Is that unusual? Is that unacceptable?
It is not unusual, and it is what makes the judgment, a judgment of the court. They are supposed to comment, and fortunately, as acting judges, we are even empowered by that.
Yes. And lastly, are the presiding officers equals among other equals in the panel, or they perform some function similar to that of a principal in a school who correct script?
They are an equal amongst equal, but for you to be nominated as a presider is because of your experience and leadership. You are not supposed to be there like an umpire, or like you are saying a school principal who says this is right, this is wrong, and all those kind of things. One of the duties that I have, that is my view, I'm not sure because I come from a leadership point of view, is that they are supposed to empower or guide us there.
Thank you very much. Commissioner Baloyi.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes.
I can't see where you are. Oh, yeah.
I'm here. Yes, Judge, in the application form where you list the cases that the first question is 16.1 that you consider to be significant and why. And then there's judgments that have been upheld and judgments that have been successfully appealed. Now, in this long list of judgments, I have identified only one judgment, and please correct me if I'm wrong, which is written by you, not written for the court. It's a mix of, the rest of them are a mix of a full bench in the Northwest Province, or you sitting with another judge, Judge Gura in some instances, and somebody else as an appeal court. And then you've got the SCA judgments where you were either a scribe or you were part of that bench. Now, it's very difficult from these. In fact, it's impossible from this. The one that I've identified as your judgment is the Bishop judgment that was successfully appealed. Now, from these court judgments, one doesn't have a way of evaluating your judgments, and this is especially important in the light of, whether fairly or unfairly, in the light of your early discussion with the Deputy President, the kind of comments you have received. Now, when one doesn't have any judgments that were written by you, it's very difficult to evaluate your ability to write judgments. What do you say? And I feel disadvantaged completely to make any comment about your judgments.
Are you referring to the judgments that I attach if I to understand?
That you have listed. You have listed in 16.1.
Okay.
You have listed what you say are significant judgments, and there's that debate about what is really significant about these judgments. But you have listed those judgments. Now, in 16.1, you've referred us to an annexure, and those judgments in the annexure are judgments that you wrote for a court. And then 16.2, the judgments there, the first one, Sheldon Lakey, is a judgment, it's an appeal.
I wrote, but for the court, yes.
Yes, and the balance of them are SCA judgments that are reflective of, I'll call it a committee judgment, and the same with all the rest of them.
Yes.
So before us here, do you accept at least that before us here, except for the Bishop judgment, where the SCA found you were wrong, except for that, we don't have before us judgments that are your judgment, not the court's judgment. That's what I'm checking with you.
It might be so, but the last part of your question, you said you might not be able to assess the quality of my judgment as stemming from the discussion with my Deputy President. I don't think that can be the case because, remember, judgments now are reported on SAFLI, all of our judgments. Each and every judgment that they are reported on SAFLI. So, and other what is it? Other platforms. So, like the GCP did, they did not just look at what I produced. They went there to check. And then that is why they are able to say what they said about me, about my writing skills.
Yes, can I put this proposition to you that you've given us judgments that you say we should look at, because you choose the judgments that we should look at. So can I, if please allow me to finish?
Yes.
Thank you. You have listed for us the judgments that you say we should look at, right? And we've gone to look at them. That's why this engagement is able to happen. And it's disappointing that from reading these judgments, one can't say anything about your writing judgments. And so when there's a comment like that, one does not have a way of evaluating it against the objective material that is here. But to comment about the GCB, it's also not helpful because the GCB doesn't say what judgments they've looked at that you say they have independently sourced or randomly sourced. They just make the statement, and I think you read it one way and I read that statement differently, but I'm not engaging with that. What I'm saying is, well, it's not even a guide from the GCB to this panel, at least, to say, go look at this judgment. This is the one that she's written. In fact, I think what they have done is to, in the summaries that they've given, is to include those judgments that I'm talking about, where you were writing with others.
Thank you. But remember, when you are answering, you are guided by the question. The question says that you wrote and that you feel are significant. So this time the question was not necessarily about the issue that is on the table, my writing skill as such. I think the key word, I looked at the issue of significance to me. Thank you.
CJ, if I could just follow up on that last part.
Yes.
Yes. And maybe on that last part where you talk about significance, I mean, looking at the Sheldon Lakey judgment, you say now in the application that it's significant because it makes the point that a woman will not be treated any more sympathetically compared to a man committing the same crime. But there's nothing like that in the judgment itself. You have read the judgment and you speak to the general principles that apply to cases like this. There's nothing distinguishing in it, and you at least not in the body of the judgment. But I'm not even sure about that. I know I don't agree with your saying it's important because it shows that a woman will not be treated any differently. Well, the law doesn't distinguish. You know, you have sexual intercourse with a minor, there are consequences, it doesn't matter who you are. And so it's not even clear to me why do you even say this is significant, especially you don't say anything about that in the judgment.
I've got two answers. The first one is that for a judgment to be significant, it does not necessarily mean that we should write that in the body. You look at the judgment as a whole and get the significance thereof in the judgment as a whole. And two, even now, if you can look at it, and that is why I said it is reported, and the reporters saw it very important that it should be reported, because there is a custodial sentence, if you can look at it, and this type of offenses are not, they are rare. I haven't read of any other, matter of this sort since then, to be honest. So it was significant to, and also to emphasize the fact that we don't differentiate a wrong because it was committed by a man or a woman. A wrong is a wrong. Thank you.
Thank you, CJ.
Thank you, Commissioner. Commissioner Steinberg.
Thank you, CJ. I'm here.
Yes, thank you, Commissioner.
Good afternoon. My one question is adequately covered by Commissioner Beloy, so I'm not going to go there. The second, I'd like your comment on something. I was specifically contacted by colleagues who commended you in a full bench appeal in which you were the presiding officer, I think about a week ago, concerning the execution of an order in terms of Section 18.3 of the Superior Court Act that involved ESCOM and another party, that you quickly and confidently saw the issue with the finding of the court below. You put it squarely to the parties,
yes.
And you then handed down your order immediately, knowing what the urgency of the matter was. Perhaps you can just tell us a little bit about that test and how you applied it and what the problem with the acting judge in the court below was.
Yeah, that was the agenda appeal last week. But I'm not sure whether, I'll briefly comment because they indicated that they want to appeal that decision, but I saw that there is a recent judgment already in the Supreme Court of Appeal which says that they don't have a second bite of the cherry, they cannot appeal further. So let's put that aside. But I just wanted to say to you that I won't go into details because they seems to want to appeal so they can exercise it, whether they will be rightly received or not, that's another thing, or another debate for another day. But the trial, the judge there, I think there were several flaws, but we concentrated, I wanted us to concentrate mostly on the requirements, which are firstly whether there are exceptional circumstances, and secondly, there are two very important requirements. One, whether the applicant will suffer prejudice if the order is not implemented. Now, the second leg, the third one, whether the respondent will suffer prejudice. Now, I think the Kodako made a mistake there because instead it weighed or balanced these two requirements instead of treating them as distinct requirements. Because there's case law here. We have a case of Justice Wallis, as he then was, which says when you check whether there's prejudice or when you deal with the requirement of the prejudice of the applicant versus the prejudice of the respondent, you don't balance. But you look at whether there's prejudice for the applicant and also look whether there is or will be not prejudice for the applicant. So the court, according, didn't do it right. They put it in the pot and sort of balanced them, which is not right according to the law that I read. But then the other problem was the test there. The test there is not, it's the test on a balance of probability. And the onus rests upon the applicant. The applicant must satisfy the court that deals with section 18.3.1 that the applicant will not suffer prejudice, will suffer prejudice. And two, which is important, and that's where the court committed a material error. One, that the applicant must also prove that third leg, the third leg being that the respondent will not suffer prejudice. So the applicant in that matter wanted the respondent to prove that, which is not what he's supposed to do or what the law says. And unfortunately, the judge fell for that. Thank you.
Thank you. JP?
After the JP.
Oh, JP? Thank you. Commissioner Ngwetobi?
Judge, I'm trying to get a sense of to follow up on Commissioner Baloyi's point, trying to get a sense of this problem that she can't understand your actual legal reasoning from the judgments you've submitted, etc. But maybe I can understand it from the perspective of just having a conversation. There was a question asked by the Chief Justice about the different types of discretion. You remember that it was right at the beginning.
Yes, Commissioner.
Yes. Now, I don't remember that you answered that sufficiently. Now, I don't want to go into a discussion about your candidature, if in fact you know the answers, but maybe you were under pressure and not expressing it fully. So there is the narrow discretion, and then there is the wide discretion, correct?
Indeed.
Yes. And the problem is that you moved into what an appeal court should do when confronted with a narrow discretion without first describing what a narrow discretion is. You remember the famous or infamous dictum of Porter Stewart, a judge of the Supreme Court in America, when asked what is pornography. Well, I don't know it, but I know it when I see it. So So it seems we must first understand what it is that we're talking about before talking about what an appeal court should or should not do with it. So can you just explain what is a narrow discretion, what is a wide discretion?
Sure. That's not an easy answer, that question.
I mean, and how do you know that you are dealing with, you've got a statute or you've got a rule or regulation. How do you know that here I'm dealing with a narrow discretion and here I'm dealing with a wide discretion? What are the features or the characteristics?
The features of a narrow discretion is where, if I can explain it, where you can see that the discretion is, in a narrow sense, it is, and it should not be sort of unfettered with. A wider one.
But what does that actually mean? I mean, this is all from decided judgments. Transformative is the main one from the Constitutional Court.
Yes, but I was going to say, we do that, we are able to do that in terms of what the courts or the Concord had decided. We take precedence from how they...
No, I accept that. I just want to know, just give me just a short understanding. A narrow discretion is where X, Y, Z. A wide discretion is where X, Y, Z. That's really what I'm looking at.
Yeah, that's a difficult one. I cannot just do it immediately like that now, unfortunately.
Thanks, Chief Justice.
Thank you. As I think we are about to finish to end the interview, did you enjoy your time in the SAA while acting there?
Indeed, Chief Justice.
Yes. The atmosphere was good.
Yes.
Okay. No, thank you very much. There are no further indications of questions. Thank you once again for availing yourself. We appreciate it very much. You are now excused.
Thank you very much to all the commissioners.
Thank you. Good afternoon, Judge Masipa.
Afternoon, Chief Justice.
How are you this afternoon?
I'm well, thanks, Chief Justice.
Yes. I have disclosed to the commissioners that many years ago you were my clerk stroke researcher. I think it must have been around 98 to 99 or 2000. Is that correct?
Yes, that's correct.
Yes. Thank you very much for availing yourself to be interviewed for a position in the Supreme Court of Appeal. We appreciate your availing yourself. I'm going to ask you some questions, and the commissioners will ask you some questions. All our questions will be directed at us getting information that will enable us to see how you fare in terms of our selection criteria that we adopted earlier this year.
Yes.
All of us will be asking you questions with a view just to look at that. We might be robust, but nobody will be asking you questions with a view to humiliating you or treating you with disrespect in any way.
Yes.
You understand?
Yes, I do understand.
Okay, all right. Well, I do know that when I interviewed you for the position of a clerk, law clerk or researcher, you had been a student at the University of Natal. Is that where you did your first and second degrees?
No, I first did my BProc degree at the University of the North, now University of Limpopo. And upon concluding that, I then went to do my LLB at the University of Natal.
Yes. And subsequently, you also did an LLM at the University of KwaZulu-Natal, is that right?
Yes, that's correct.
Was that in 2015?
Yes, it was awarded in 2015.
Yes. At the time that you finished at university, you were not thinking of following the legal practice route, is that right? You didn't think that you wanted to practice law, is that right?
Yes, at that time, but prior to that, and when I obviously registered for my law degree, I had intentions of practicing, but then I don't know what changed somewhere along the way. It seemed like the life of legal advisors were easier, I guess, to me, and I thought that was the option that I would take.
Yes. You practiced for about, was it about 16 years before you were appointed to the bench?
I think it's slightly below that, Chief Justice, but I did not work it out now, so I cannot give the precise number.
Yes, but it's more than 10 years.
Yes, it was more than 10 years.
Yes. And was your practice in Durban?
Yes, it was in Durban.
And in terms of a variety of work, how diverse was the work that you were doing?
We did a lot of, I first practiced in a biggish company. There was about 4 directors and, a number of associates. So we had different departments that were running in the firm. I did mainly labor law, and I did some maritime law work. And then we after a couple of years, split the practice, and I went into my own firm, and then I did some commercial work, continued with the shipping work and the labor work.
Yes. How many years have you been a judge now?
This is my 8th year.
8th year.
Yes.
In the High Court, have you been involved in criminal trials, civil trials, criminal appeals, civil appeals, motion court throughout?
Yes, I have. I think we have. I like the way that our court operates because it exposes you to everything at almost about any given point in time. We have a system where almost every Friday you're sitting in appeals. That would be appeals from the magistrate court, and sometimes at the beginning of the sessions you'd have the full court appeals sitting Mondays, Wednesdays, and Fridays. And that's in between that you have motion court, you have civil trials, and you have opposed applications. And that's when you're in the civil court. So you move every session. Then when you're not in the civil court, you're in the criminal court. You obviously run in criminal trials, but you still do appeals. And when you're doing appeals, you're not limited to doing civil appeals or criminal appeals. Whichever appeal is allocated, then you attend to that.
Yes. Have you had the opportunity of dealing either in the High Court or in the Supreme Court of Appeal when you were acting there, with cases where the court is asked to declare legislation constitutionally invalid?
There's a matter that I dealt with in the High Court, not in the Supreme Court of Appeals. Well, come to think of it, it was not necessarily legislation, but that's how it was couched, that I declare a specific rule or regulation constitutionally invalid. It involved with a certain rule which is applied by private schools infringe on certain rights in the Constitution. That's the right to education I think it was the right to education, but then in exercising, in dealing with the matter, I also looked at the issues relating to the interest of the child who was involved in the matter. They had sought for me to declare that constitutionally invalid.
So was that the matter of Lena, who was denied the opportunity to write exams?
Yes, that's correct.
Okay. So you were not asked to declare legislation constitutionally invalid, but you were asked to declare some regulations applicable at the school?
Yes, not at the school, but it's in respect of private schools.
Oh, okay. And what was your conclusion?
Well, I concluded that it was invalid, but then obviously it did not obviously take the step that when you declare a legislation constitutionally invalid, it would follow, because ordinarily once a legislation is declared constitutionally invalid, it has to obviously be taken to its operation would be suspended, and or some other interim measures be put in place whilst the matter is referred to the Constitutional Court for the Constitutional Court to actually confirm the declaration.
So it was not legislation, it was some regulations.
Yes.
But did that matter give you an opportunity to know what the approach is that a judge is supposed to adopt when determining whether legislation is inconsistent with the Constitution and invalid, or
Yeah.
did it not give you that opportunity?
Well, I believe that it did. Yes.
What is the approach?
I looked at, as I said, that I had to consider the rights that were there in respect of that child. So you look at the legislation, the impugned legislation that is thought to be declared invalid, and then you look at the right that it infringes on, and then whether that legislation serves a legitimate government purpose. And then you balance the rights, looking also at the limitations clause in terms of Section 36 of the Constitution.
There are two types of discretion. Are you familiar with them? And if you are, what is the difference between them, and what is the legal significance of the difference between them?
The two types of discretion exercised by a judge is there's a narrow discretion and there's a wide discretion. So in respect of the narrow discretion, you are limited to or confined to the rules, the statutes, or the regulations that you're dealing with or focusing on in respect of that matter. And in respect of the wide discretion, you have flexibility in terms of how you exercise that discretion.
How many acting stints have you had in the Supreme Court of Appeal?
I'm, as of yesterday, on my fourth stint.
On your fourth stint?
Yes.
And when you put all the months that you have been there together, about how many months does it come to, more or less? A year? 4 terms?
No, it's not yet 4 terms. I started yesterday my 4th term. My appointment started yesterday for the 4th term.
But you have had 3 terms?
Yes, I've had 3 terms.
Oh, okay. You are on your 4th term?
Yes.
Oh, okay.
So when I count the months, they work out so far to about 9 months.
Yeah, if you say 3 terms, that gives us an idea. How was your first stint, acting stint in the Supreme Court of Appeal? How, did you enjoy it?
I did, but it was obviously a different environment for me, with a different court, different ways of doing things. So it was a learning and challenging experience. Yes.
I assume the second stint was much better.
Yes, it was.
Yes. And the third one, are you close to cruising?
Well, I'd like to believe that, but it's always a subjective view. You may see yourself, in a certain way, and other people see something different. So, yes.
Oh, okay, all right. I will now allow the Deputy President of the SA to put questions to you.
Yes.
Thank you, Chief Justice. Good afternoon, Judge Masipa.
Afternoon, Judge Betsa.
Your last acting stint at the SCA was in May
Yes, that's
this
correct.
year. I see from the comments of the GCB that they say you possess extensive experience in the field of labor law, as well as experience acting in the Competition Appeals Court, and that you would make a valuable addition to the Supreme Court of Appeals bench in those areas of law.
Yes,
Did you
I
see
saw
that?
Yes, I saw the comment.
But what seems to have been lost on the GCB is that the SCA doesn't have jurisdiction in labor law matters, nor in competition appeal matters. Those go to the Court or Constitutional Court.
Well, there's certain types of matters, employment law matters, that that have gone and still go to the High Court, and appeals of those matters would come obviously to the SCA if taken, and not through the labor appeal court system.
But ordinarily, the labor court is a specialist court and it has exclusive jurisdiction.
Yes, that's correct.
Then, for its part, the Law Society of South Africa recommends that you do well with more acting stints.
Yes.
They say you should be given more opportunities to act in the SCA, to develop yourself, such that you would be able to present yourself as a strong candidate.
Yes, I noted that.
Yes, and what's your response, if any, to that?
Well, I obviously don't know the reason why they're saying that. I think it was about the issues of the judgments. I think when I recall that the judgments that I submitted were the ones that were co-written with other senior judges in the court. Well, in addition to the judgments that I submitted, there's, well, in my view, there's judgments that I have not submitted, which some of them came after I had submitted my application, that although I co-wrote them with other colleagues, I played a major role in the ultimate outcome, and I can about say, confidently to myself that I own those judgments. The fact that my name appears with someone else does not necessarily mean that I do not know how to do my work. As is apparent from the other judgments that I submitted, although not in the Supreme Court of Appeals, most of them are appeal judgments that are submitted. In the Supreme Court of Appeals, the judgments that I about can say I'm claiming, and although there were other people that I co-wrote with, it's about 8 judgments. I have I have the ability and the confidence of standing as an independent person, and hence some of those judgments are matters where there were dissenting judgments that I either wrote or I played a major role in their being. So, and in addition to that, the other matters where my name does, there are matters where my name does not appear as somebody who co-wrote a judgment. Because to me, when a matter comes to court as an appeal matter that has to be determined. It is not about my name appearing as a scribe of a judgment, but it's about the ultimate decision that is arrived at by the court, being the 5 judges or the 3 judges that would have been sitting there. So no matter how much of an effort or contribution I play in those matters, I have not said to people, because of this contribution that I played in the matter, my name must appear on that judgment, despite the fact that I would have played major roles in those judgments coming out. So when a judgment comes out, and out of the 5 judges, my name appears there, I'm happy. I take pride in that, and I would know that I did all that I had to do to make contribution to that judgment coming into being. I guess I don't know. Obviously, people who do not get involved in writing appeal judgments would not know what involvement the judges get to do.
Would you care then to enlighten this commission on how it came about that judgments that were initially allocated to you as the sole scribe ended up being co-written?
Okay. So
with a senior colleague?
Of the I think it's 4 judgments that were submitted as part of the pile of my records. There's 2 judgments that were initially submitted, allocated just to me. The one is the RAF matter that I co-wrote with Judge Govan. That was I think the first matter that I dealt with when I went into that court, and I had obviously prepared a draft, and I spent some time with Judge Govan getting his views and his inputs, and somewhere when we were about finalizing the matter, he said to me, I'm of the view that I've contributed a lot in this judgment, so my name must appear. And well, I don't know if I could say yes or no to him. So he's a senior judge and he's telling me that. And I'm not going to say that he did not contribute towards that judgment being written. But similarly, as I said, I've contributed to other people's judgments in the same way that he contributed to my judgment. But I never said to them, my name should appear in that judgment because of the contribution that I made. Because to me, in my view, that matters was allocated to that judge. And as long as my name appears as one of the 5 judges who had written the judgment, it was enough for me. The second matter.
Perhaps before you go to the second matter, insofar as that one is concerned, what got to my ears was that because of the substantial contribution that he made to your draft, that was the reason why it was thought that it was only fair that his name should also appear as the co-scribe.
Yes, I did say that. I don't know if you missed that. I said I accept that he did make a substantial contribution.
Yes.
Yes, I think, let me leave it at that. I'm not disputing that he made a substantial contribution. What I was saying was, I've made similar types of contributions to other people's judgments, but I never said to anybody, my name must appear on that judgment. I'm not saying he was wrong to do what he does, and then I accept that he had the right to do that. So should I proceed to the second matter?
Then there is another judgment that I allocated to you and another permanent judge,
yes,
who subsequently reported to me that the 2 of you had agreed that you would be the sole scribe and wanted to find out whether that met with my approval, which I endorsed.
Yes. So I think it's the discovery matter. I did a draft of that judgment. I gave it to, circulated, well, she said to me before I even circulated, give it to me for me to have a look at, and then I'll discuss it with you. Then I did that. She made some input to the judgment, and I looked at them and considered them and added or amended where it was necessary. And then I circulated the judgment to everyone, and she and the other judges put their comments, which is, ordinarily what my expectation is what's happening, in the court. I worked on it, and all of them were happy with the draft that I ultimately had. And then I think it was with you then, we were waiting for you to comment on it. And then you were not happy with how some of the, how it looked. And then you then took upon yourself to work with me on it. But then the three other judges that had received the judgment were happy when I gave it to you.
But for your information, I can indicate to you that they hadn't read your draft before I got involved, except for one of them, and then produce the final judgment together. And that was the MEC, Police, Roads, and Transport Free State.
Oh, okay, so it means it's three judgments. You're talking about a different matter, and I'm talking about a different matter, because I said I'm talking about the discovery matter. I was talking about the discovery matter. The MEC matter, I did get comments before it came to you. And in a similar vein, I worked on the comments, and I think, I'm not sure if it's the one that Govan was involved in. If it was, he was the only person that had not commented other than you. The other two judges had commented. I had worked with them on their proposed amendments, and they were happy when it came to you. When you spoke to me in respect of that MEC matter, and that's the reason that you gave to me as to why your name is to appear on that particular one. There was an issue about the application of, the manner in which that particular matter was referred to the High Court. And when we were in court, counsel was asked, do you think that this matter deserved to be here in this court instead of the appeal being dealt with in the full court? And counsel had accepted that it did not justify being in the Supreme Court of Appeals. And then I had written, as part of the judgment, why that matter should not have come to the Supreme Court of Appeals, and stated that should the High Court in future refer matters which were not befitting, then the court would take the necessary action, I think, in terms of section 16, and then you said, because of the comments that, the serious comments that are being made in respect of how the judges of the High Court deal with matters, it would sound better if it's coming from a senior person from the Supreme Court of Appeals and not from you as a judge of the High Court. So, and you said that's the reason why it is necessary that your name appear as a co-scribe in that particular judgment. And that was the reason that was given to me.
Are you suggesting that I made no substantial contribution
No,
to the
definitely
final
not.
product.
Definitely not. I'm not saying that you did not make any substantial contribution.
Okay, then there's the third judgment, which is in fact discovered.
Yes, I started, when I moved from the RAF matter, I said the next matter was the discovery matter, and then I dealt with the discovery matter. And then when you said to me, it's the MEC matter, I said, no, I had been addressing the discovery matter. I had not been addressing the other one.
Yes. Okay, but that one was, we were the designated scribes right from the outset.
Yes.
You and I.
Yes.
During the last week of May, and I'm duty bound to say this, of your own accord, you approached me, indicated that you are aware that the SCA had advertised and that you would not be making yourself available for those positions. And I see from the questionnaire you signed the form on the 19th of June 2023. What happened that caused you to change your mind in less than a month after you had indicated to me that you need more acting stints? In fact, that's the reason why you have been invited back in November.
Well, as far as I remember, when the talk that I had with you, I said to you, I'm aware the positions have been advertised, and what are your views in terms of that? And then you said, in your view, I should be given more acting stints. So yes, and then you said, well, when that becomes available, an opportunity, then you'd be invited. Because in fact, I think before that, you had indicated your intentions to get me to come back. I think it was supposed to have been that the June term but then there were obviously some issues or some changes there which led to that not happening. But then in considering, I guess, I looked at the time that I spent there, the need, the views that I formed about how certain things were happening in the court, and I thought I could make a contribution to the court.
But you didn't find it necessary, just as a matter of courtesy, to say, don't be surprised to see my name in the head. I've changed my mind.
I think when I was next to you, although you yourself said that it was not easy for me I do not go into the office and I'm not approaching you, and I indicated my reasons to you why. So when I was away, it got worse. In that same vein of my respect of authority, I do not, unnecessarily burden when I feel, unless I really have to be doing that.
Thank you. I'll leave it there. Thank you, Chief Justice.
Thank you. Minister?
I'm fine, CJ.
You are covered.
Yeah.
Commissioner Tutovu?
Thank you very much, CJ. Good afternoon, Justice Mali.
Masipa.
Oh, Masipa, sorry. Sorry, Masipa. I'm covered.
No, I understand.
I'm covered,
You were
CJ.
expecting
I'm
justice.
covered. One day I'll tell you why I'm covered.
It was the wrong script.
Commissioner Dodo, do you want to use this time?
It's okay. I'm
You're covered.
covered.
Oh, okay. Oh, you'll tell her some other time.
I'll tell you.
All right. Okay. All right. Commissioner Marumuahai.
Thank you very much, CJ. Good afternoon, Judge. I'm
Afternoon,
here.
Commissioner.
I'm here.
Oh, sorry. It's because when I was looking there, I saw the hand and
Yes.
I didn't, and I apologize for that.
When you get a chance to be a judge in that court, and you are one of the judges who are doing duty and looking at the applications for appeal to that court, and you find that there is an application that was brought, but it was brought out of time, because a lot of things can happen sometimes. I mean, think about maybe a civil matter where it was decided last year in November. And it so happens that the lawyers involved, they got out of the matter and the matter died, but somebody picked it up and they convinced the litigant to appeal. Under those circumstances, what application ought to have been made for the Supreme Court of Appeal to hear the matter, and what is the test that ought to be met for that matter to be heard?
Is it, is it you said the application for leave to appeal?
Any application that is brought late to that court, because the test will be more or less the same.
As far as I know, remember, it's an application that's similar to a condonation application, and therefore the principles relating to condonation would have to be considered, which is obviously considering the degree of lateness, the explanation that is proffered for that lateness, the prospects of success in the matter, I think it's the balance of convenience, whether it favors the granting of that application.
All right, thank you. My second question is in relation to the judgment that you wrote in the High Court, KV versus WV. It's also in your question.
Yes.
That was dealing with domestic violence.
Yes.
I understand that you might not have it there, so I'm not going to deal with the actual, but something that arises out of it, where I need your input on it. One of the things that you mentioned in the judgment is in relation to the safety of the person who has been granted a protection order, and why that thing is important. I just want to ask you this question. In the magistrate courts, usually, we see interim protection orders in particular being used as an eviction order of some sort. In other words, and now that brings into play the challenge between the gender issues and the Section 26(1) of the Constitution, the right to housing. How do you think that first, is there a conflict between the two? And assuming that there is, how should we balance that conflict where somebody should be protected by making sure that there's an order that says the perpetrator of this thing should not be where this person is. But you find that the perpetrator's housing, it's where he or she is told to get out of. How do you balance that tension, if there is tension at all?
Well, I believe that there would be tension. Well, obviously not in all instances, because obviously in some of the instances, where an order is made for somebody to vacate the house, they're able to leave and find alternate accommodation for, up until the order is either discharged or confirmed. But then I dealt with a matter where it involved two housemates. They're both renting in the same premises. And the order that was made was such that it still allowed them to live in the same premises. Obviously, the enforcement of that is a challenge because if you're sending people back to the same house, and for instance, where there's this physical abuse involved, I think what was said in the judgment was sometimes the mere existence of the interim protection order would restrain the other person from breaking the law. But then it's not in all instances that would happen. And in some of the instances, it would even lead to dire consequences because now the person you actually took me to court and now you have an order against me and then, somebody may just be killed as a result of that. So it is
I guess, sorry, Judge. I guess my question is, can you use an interim order, an interim, protection order to evict someone? I think that is the question that I'm actually asking. Can an interim protection order be an instrument that is used to evict somebody from a particular house? I think that is basically the nub of my question.
Is it evict as in temporarily whilst that order is interim?
Both temporarily or even permanently. Can we use an order that says this person on the interim has done 1, 2, 3, 4, 5, there must be a return date for this person to come to show why this order should not be made final. Then in order for us to enforce, yes, the enforcement issues might be, they might be worrying, but I'm not asking about that. I'm just asking from perhaps even on an abstract level, can or should, because we see this happening in the magistrate court almost every day. Is that something that should be happening? Perhaps maybe that's the question I'm asking, and I will leave it there.
I don't think it should be happening. But then I think what the court would be looking at is the risk involved in, the life of the person. Hence, I'm saying it would depend on the nature of the domestic violence that is involved in the instances. You can make an order and say the person can stay, but then where the risk is, or the harm actually is much more serious, I think you can do that.
Thank you very much. Thank you, CJ.
Thank you, Commissioner Singh.
Thank you very much. Good evening, Judge Masipa.
Evening,
I don't want to make the mistake as my colleague there. I think we're thinking about the last interview and when we're going to go to bed and have dinner. Thank you very much. In a previous interview, there was a complaint when you were an attorney.
Yes.
About a client coming in and you withdrew a matter and so on and so forth. I'm not going to go into the details. And we were told that the matter is being appealed by yourself.
Yes.
Has there been any progress with regard to that appeal?
The appeal was heard, I think, in February of 2021. And it was heard by 2 judges from, I think, the Eastern Cape. And they rendered a judgment a few months later and found that the decision of the Law Society was wrong, and they set it aside.
That's good to know. And I note that just reading at some of your judgments, your independent-mindedness, where you dissented in the dissenting judgment. There were 4 senior judges at the SCA, and you dissented. It was a matter about rugby and injury.
Yes.
Can you just lead us through that and what made you come up with a dissenting judgment in that regard?
Sorry, can I do?
Can you just take us through that case?
Oh.
And what in law made you dissent from 4 senior judges?
The matter involved the Minister of Education, where a schoolboy was injured at a rugby match. What had happened was that the school it was an inter-school event, and he was not from that school. The school that was responsible for the events was responsible for arranging that there's proper care for, there was several sporting events happening, and that all the medical or the necessary first aid facilities were made available at that school. And the visiting school where the boy came from had gone to that school, and they went and also satisfied themselves that the requirements that they had were complied with. The boy was tackled. Okay, what had happened was, in terms of the procedures that were available at the time, that was I think in 2006, what was needed in order for a rugby match to take place was a stretcher and a neck brace and access to medical care. It was not necessary, for instance, that there be an ambulance, but there was a need for first aid trained person to be present at the premises. So what the school did was that they engaged the services of a service provider who was providing services to, from what the evidence said, the whole of Potchefstroom, including the university. He was known, and because everyone was using him, they were booking him in advance, and the school had done that. They looked at his calendar and looked at their sporting calendar, and that indicated that we're going to have these events happening, and they booked him. In the morning of the event, checks were done, the stretchers were there, the neck braces were there. The match started. And the person that was responsible for the running of the match was, in fact, the referee. If the referee, the policy was the referee must satisfy himself that all the necessary tools are there, all the first aid SOEs were there. And if he is not satisfied, then the game will not start. So he was satisfied that they were there, and the match started. This boy was injured, and they were supposed to remove him. Well, no, the referee indicated that he should be removed because he was taking time from the ground or the field. And they then, seemingly, there was no stretcher. And the service provider and his staff went and they lifted that boy, and he had apparently already sustained a first injury on the spine, and when they lifted him, because they did not put him on a stretcher, he sustained a second injury. They put him outside, and then they took him to the hospital. Obviously, he was very badly injured. So my issue was the role that the school and by virtue of the position that the MEC holds, he is then the responsible person for the school, had done all that was expected of them to make sure that the necessary first aid services were there. That person was the only service provider who was known or who was being used by everyone in that area. So the difference that I had with the other judges was that they wanted to apply, or they applied, not wanted, the subsequent or later first aid, I'm going to say first aid care or requirements, which were in place at about the time that we're now dealing with the appeal judgment versus what was in place in 2006 when this child was injured. The requirements that they just needed to have a stretcher and the neck brace had since changed. It is necessary to have an ambulance and a whole lot of other resources, and probably even have a medical trained person at the field. So my issue was that we're supposed to be looking at
what the position was at the time when this injury was sustained, what we expect that the MEC or the schools ought to have done as at that time. And I think the other issue was that there was also an expectation that the school ought to have phoned them or communicated with the Health Professions Council to find out if this person was registered or not before they engaged his services. So in my view, everyone else was using him. So, my analogy was that when we all go to medical practitioners every day, we never inquire from those medical practitioners, I want to see your medical, your qualifications, I want to see your registration details with the Health Professions Council. We accept that they've been there, they've been providing services. If I'm sick and I'm going to see the doctor, he treats me, it's fine. So there was, I felt, an unnecessarily onerous duty which was expected of the MEC to have gone and inquired or investigated from the Health Professions Council whether this particular person was registered with the council or not. Because in any event, it was not a requirement in terms of the SARFU rules which applied in 2006. In 2006, all that was required was a neck brace, a stretcher, somebody who is trained for first aid services. Not even registration with the Health Professions Council. So that is how I differed with the other judges.
No, thank you. You're entitled to your view, but I think you know when any event is held nowadays, whether it's at a sports stadium or anywhere else, you have a safety officer that's got to ensure that there's compliance. I mean, you can't say, well, we've got an ambulance there and there's nobody in the ambulance and they don't know what to do, and we have a doctor there and the doctor is a fake doctor. But anyway, you made your judgment and you dissented.
No, but I want to explain, just please can I explain? Okay. My issue was not that there was nobody liable for the injuries that were sustained by the boy. My issue was about the service provider. The service provider is the person who was responsible. He's the one that failed to provide all those necessary, the stretchers and whatever else that he needed to be there, not the MEC. And that was my issue. The MEC, in my view, had done all that he needed to do to ensure that the place was safe. The fact that in the morning, so secondly, the second person who was responsible was the referee, because as soon as the referee realized that there was a problem, he was supposed to stop the match. And he did not do that. And that is the reason why the Referees Association actually settled that matter, because in their view, there was clear issues of negligence which were visible. The second, the service provider didn't even defend the matter. He did nothing. He just let it run. And I think there was not even any judgment that was granted against him, despite the fact that he was, in fact, the negligent party.
Chief Justice, just one more. In that same interview, you said that male lawyers at that time are generally dismissive of your abilities. Has that changed over the years?
In the courts that I work in, no, it has changed. I've seen a lot of respect coming from them, but then it's like a subtle thing that you feel, but you can't put a finger on it.
Thank you, Chief Justice. Thank you, Judge.
Thank you, JP.
Thank you very much, Chief Justice. Good afternoon, Judge Masipa.
Afternoon, JP Mnamba.
I'm just going to ask you about the one judgment you discussed with Deputy President Betze, the one you say you co-wrote with Justice Govan.
Yes.
Is that the matter that related to the panel lawyer dispute between the RAF?
Yes, that's correct.
Right. Am I correct that when the roster came out, that matter was allocated to yourself?
Yes, that's correct.
How long did that judgment take to come out?
I cannot recall offhand, but it took quite a bit.
What?
It took quite a bit of time. I cannot
Yes.
recall. I have not looked at the.
Yeah, well, it wasn't delivered in the term it was heard,
Yes.
and it was not delivered in the next term. It was delivered in the third term from when it was heard. Am I correct? I'm not there, you are there.
No, I don't recall. I think, no, I don't want to respond and say something. I did not check the time.
But it took some time.
Yes, I did say that.
My last question about this, CJ, is, as a judge, you say this year is your 8th year as a judge. Did I understand
Yes,
you correctly?
that's correct.
You are acutely aware that in the first instance courts, there are certain matters that go on appeal that we look and watch and wait because we want guidance as first instance courts.
Yes.
Isn't this one of those matters?
I think at the stage when that matter was heard, it had actually gone beyond that. In fact, one of the issues that had to be dealt with was whether the matter was moot or not, because what was being sought to be appealed against had about lapsed. The order had, I think it made reference to the fund doing something within a period of 6 months, or there was a specific period that was given by the judge from the High Court. At the time when the appeal was heard, that date had already passed.
I see. Yeah, I know there was Section 18 processes.
Yes, there had been a Section 18 application,
Yeah.
but that was not what we were dealing with.
Yes. Okay. You say it took a bit of time. You know, my experience when I was in that court, we wrote judgments in the same term we got the matters, and we had the matters. Let's say I'm wrong that it was delivered in the third term after it was heard. Some of us frowned when we saw the matter going over to the next term.
Yes.
And we wonder why. Now, can you explain, because you say it was allocated to you, you say it took a bit of time. What was the reason? Was it a complex matter?
Well, and this is not the only matter in respect of the comment that I'm going to be making, is that some colleagues don't comment, they just keep quiet, and you've handed, you've circulated a judgment and no one comes back to you to say anything. And then you have to follow up and follow up and follow up, and so I think towards the end of the term, that's when Judge Govan was about to be leaving. Then I spoke to him about it, and that's when he then said, I'll have a look at it. And I think it was, in fact, about a day or two before we were leaving. That's about the first time that I had a comment from one of the judges that were there.
I see. CJ, thank you very much. I don't want to prolong this one. Thank you.
Thank you. Commissioner Moiman. You are covered. Thank you. Commissioner Barnett. You are covered.
No.
Okay, go ahead.
Thank you, Judge Masipa. I just want to confirm, first of all, the comment that you had in respect of the appeal that you had against the Law Society of KZN. So, just as I don't know, on my side, there seems to be quite a big echo.
Yeah, you are breaking, kind of. Maybe just start again. Let's see.
Yes, first of all, I just want to confirm that I have read the full judgment, and I agree with you fully that the court had found that you acted totally under pressure situations in the best interest of your client, and that the conviction by the Law Society was wrong. So I just wanted to confirm that I had read that judgment in full. It was thanks to the Secretariat for sourcing that for us. What I would like to ask you about is the John Wesley School judgment, and not so much about the principle involved, which is a constitutional principle and which you've already referred to. My question is specifically in relating to the costs. You'll notice in the order on page 28 of the bundle, if you do want to refer to it, there's no order as to costs in that matter. And I think costs are not discussed anywhere in the judgment. Sorry, I'll give you an opportunity. Page 28. Paginated page.
Yes. Yes, you
Right.
said the order.
Yes, so the order is on page 28.
Yes.
And if you just turn around the next page, the question that is asked by the respondent, or the praise of the respondent, in praise C, the respondent, at least the applicant asks that the respondent be directed to pay the costs of the application.
Yes, I see that.
Did you follow that? All right. And yet, in the rest of the judgment, there's no discussion of the costs. No reasons given why there's no cost order, and eventually you make the finding on the principle, but you don't deal with the cost at all, or give an explanation of why you are not dealing with it. So I was wondering if you could comment on that, please.
Ideally, the issue of cost should obviously be addressed and be dealt with in a matter, but where there's no cost order made, the fact that the judge has not dealt with that or reflected it does not mean that it was not considered. But I take the point, and ideally, in the other judgments that I deal with, I will, make a closing paragraph to address the issue of costs.
In fairness to you, this was a 2018 judgment, and the latest judgment we have dealt with costs.
Yes.
Thank you very much, Judge. Thank you, Chancellor.
Thank you. Deputy President of the SCA.
Thank you, Chief Justice, for indulging me. Judge Masipa, in relation to the road accident fund case that the Judge President indicated to you that took long to be delivered, did you at any stage approach the judge who was the presider to express your frustration at the fact that you have circulated a judgment in good time, and the other members of the panel were not forthcoming with their comments or suggestions? Or if you didn't get joy from him, approach me, as I indicated to you, that if you had any challenges, don't hesitate to discuss those with me.
Sorry, I'm quiet because I'm trying to recall. I did speak to him. I cannot recall if I spoke to him after I had spoken to Judge Govan, because I remember indicating to him that
Judge Govan is looking at, I'd spoken to him and was looking at the draft, and then he said, let's wait and see what Judge Govan comes back with. But I think it was after I had spoken to Judge Govan.
Thank you. In your list of judgments that you consider as significant, you have the Quaffel Close Corporation case, where in the narration at page 14 of the bundle, you say that the parties were agreed that the matter was moot, and you similarly formed the same view. Shouldn't that then have been the end of the matter?
Yes, in fact, to me, that was the beginning and the end of the matter, because I actually, when the matter was being addressed in court, was the one when counsel sought to deal with the merits of the case that I said to him, in my view, we should, and please address us on the issue of mootness, because that's the main issue that would bring this matter to finality. I don't recall, is it the one that I said I'm dealing with that, but in the event that I am wrong, then I dealt with something else.
In your narration, I cannot discern why you consider that case to be significant. The parties tell you it's moot. You also accept that. So that should have been the end of the matter. The appeal should have been struck from the roll. And yet you proceeded to deal with the question of the court order that had been made by the High Court. The judgment itself commences at page 63.
Yes, I'm actually looking at that.
Are you looking for
Yes, sorry,
an
Chief Justice, I was,
explanation?
sorry, I apologize.
Hmm?
I was just trying to get to that point. There are instances where a matter is moot, but that there's some issues that remain live that would need to be addressed. This would have been the reason why, because of the seriousness of us leaving this matter and not attended to, that we proceeded to deal with the issue of costs.
But the focus of my inquiry was that you found that the matter was indeed moot and that the interest of justice did not dictate that you should nevertheless deal with the merits. And that once you came to that conclusion, that should then have been the end of the matter.
Yes, I take note of that, but for some reason, the three of us seem to have agreed. I see that it ought to have been that way.
Thank you.
Thank
Thank
you.
you, Chief Justice.
Thank you. I think we have come to the end of the interview. Thank you very much once again for availing yourself. You are now excused.
Thank you.
Thank you.
Thank you to everyone.
Good afternoon, Judge Mutali.
Good afternoon, CJ and the commissioners.
How are you this afternoon?
I'm well, CJ.
Thank you.
Thank you for asking.
Thank you very much for availing yourself to be interviewed for a position in the Supreme Court of Appeal. We appreciate your availing yourself.
Thank you, CJ.
I'm going to ask you questions, and commissioners will also ask you questions. In doing so, we will be bearing in mind selection criteria that we have adopted as a commission. We'll be wanting to see how you fare in terms of those selection criteria. But we might be robust in questions that we put to you, but there is no intention on anyone's part to disrespect you or not to treat you with courtesy.
Thank you, CJ.
Thank you. Are you ready?
I'm ready, CJ.
Okay. You hold a BA law degree and an LLB and an LLM, is that correct?
Correct, CJ.
BA law you got from the University of Western Cape,
Yes, CJ.
and the LLB as well.
Yes, that's correct, CJ.
And the LLM you got it from the Cardiff University of Wales, UK?
That's correct, CJ.
Yes. Was your LLM a dissertation one or coursework?
We did coursework part dissertation. It was in commercial law. I focused on international tax law, international trade law. Yes.
Yes, okay, all right. You started your legal career as a public prosecutor, is that right?
That's correct, CJ.
That was way back in 1989.
Correct, CJ.
And at some stage you became a state advocate and a senior state advocate. Is that right?
Correct, CJ. That's correct.
You were with the SIU also at some stage.
That's correct, CJ, after I resigned from the NPA.
I see that you are a product of the aspirant judges program that was conducted some years back.
Yes, CJ, I joined that program in 2008. It was a year's program consisting of full-time lectures as well as mentoring in various divisions of the High Court for 2 court terms.
Yes. Now, you never practiced at the bar?
No, CJ, I played it very safely.
You played it very safely?
Yes, CJ, that was the reason. I just couldn't take the decision of not going without a salary was so daunting.
Oh, that was the challenge.
That was the challenge, CJ.
Okay,
so
no,
I really
understand.
didn't want my decision to impact on other people who had not taken that decision.
Okay, you also didn't want to be an attorney?
No, CJ. It's not a question of not wanting to be an attorney.
It's the financial challenges.
Yes, it's the financial challenges. In fact, I joined the NPA. I became a prosecutor.
Yeah.
That also was by default, because when I did not make it in my final year LLB, I failed one subject which I just could not accept how. And then I discussed with my parents that I was not going to go back full time. There was this arrangement of registering as a special student and then not attending lectures, not paying fees, and then you simply avail yourself for the final exam. And this is what I opted for. And because I didn't have a bursary, my parents were footing the bill all the way. I thought this was going to really be unfair of them to go full-time to university all the way to the Western Cape for one course.
Yes.
Really, it was going to be extra expensive, although they were really worried as to my decision. But I said, well, incidentally, when I was home during holidays, I had put in an application for an appointment as a prosecutor, and I went to check, and the application was maturing. I was given a choice at the time of which station I would go to.
Yeah.
And then I made the choice, and then I went, and at the same time did not forget the obligation I had made with my parents that I will show you, I will manage this without going full-time.
Yes. And then you acted in the Land Claims Court in 2010 from June to October, is that correct?
Yes, CJ, although it went beyond October after my appointment, I was appointed on the 31st of October 2010 as a permanent judge.
Yes.
But I spent some time because the JP at the time in the Eastern Cape mentioned it to me that he won't have anything to do with me. How this happened was I came for an interview to the JSC. It was on a Thursday. I was recommended. And then on a Friday, I received a roster from the Eastern Cape, placing me in various courts in the Eastern Cape. That was at the time the president had not signed on the dotted line. But the JP at the time had given me duties there. And then I started asking myself a legal question that I still have a contract with the Land Claims Court, which was extended. And BAM JP at the time was not willing to release me. He had so much for me to do. And it was at the time his health was also failing, and so part of his duties were given to me. And so on a Friday, when the JP then in the Eastern Cape called, incidentally, BAM JP was in my chambers to hear about the interview I had gone to on the previous day. And then I said to the JP, incidentally, BAM JP is in chambers with me, please talk to him. And then he was clear that this is not on, it's not sanctioned by the law, there's a contract with the Land Claims Court. As to how Mjali AJ would go to the Eastern Cape now, in what capacity, because there was no acting appointment in the Eastern Cape at the time.
So you continued in the Land Claims Court until there was
the end of term.
A proper appointment in the High Court?
Yes, CJ.
Okay. So you have been a judge of the High Court now from 2010 October to, that's about what, is it about 13 years?
13 years on a permanent appointment, but including my acting stints, CJ, because I started acting in the Northern Cape High Court in July 2009. And I acted there continuously until I even forgot that I was still an acting judge there. And then
you thought you were permanent?
Yes, I was so happy there. I enjoyed myself there so much that I would sometimes be alone during recess, manning the court there.
But so when you went to the Land Claims Court, you were coming from the Northern Cape?
That's correct, CJ. At the Northern Cape, I was there from July 2009, and I only left the Northern Cape at the end of May 2010.
Yes.
2010, yes.
Okay. In the High Court, in terms of the experience that the High Court in the Eastern Cape gives you, what kind of branches of law do the matters that you have been dealing with over the years, under what branches of law do they fall, generally?
CJ, I think I have dealt with many branches of the law, starting from the criminal law, the civil, motion court, divorces, insolvency law, contracts.
And how many acting stints have you had in the Supreme Court of Appeal?
One, CJ, and to be exact, it was two months.
It was 2 months.
Yes, it started from October last year, 1st October last year, and ended on the 30th of November last year.
Yes. And how did you find it?
I found it refreshing. It was, there was some learning areas. There were obviously learning areas there. And I found the procedures employed in that court, working. And I was impressed before I even started there with being given first the material that I was going to work on in the form of records, which were couriered directly to me. And I was given the phone numbers of each and every member of the court there that I would be interacting with. And so when the petitions came, I was able to interact with the members even before seeing them.
Yes.
So you knew who to call and when and how. It was it's a well-oiled court, if I may say.
Yes. Now, either at the High Court or at the Supreme Court of Appeal, have you had a chance to deal with a matter where you are required to determine whether legislation is constitutionally valid or not?
Yes, CJ, at the High Court, it was early on after I joined in Mthatha.
Mm-hmm.
This is a piece of legislation. I think I attached a judgment of Kotliso versus the state, which judgment went through the Constitutional Court. I referred it for confirmation to that court, but the Court did not agree with me in that regard. In fact, it was not me alone. I was with Griffiths J. It was an appeal dealing with the provision that pertained in the
Transkei. One about the feet of some animal?
Yes, the vulture feet.
Okay. Yeah.
And then this piece of legislation being applicable exclusively in the former Transkei and different from the parts of the province of the Eastern Cape. And I found because the sanctions and as well as the strict liability that came with that kind of legislation discriminated between the citizens of the very same province.
So is that the only matter where you got exposure to how you deal with, how you determine the constitutional validity of legislation?
CJ, as far as I remember, I think yes.
Do you remember how you go about doing it? What you do when you are required to do that? What you look for and what you do?
CJ, as far as I remember, you look at the legislation itself, its impact on the people concerned. And then you look at whether this legislation differentiates or discriminates. You have to determine whether it is discriminatory and how, and whether the discrimination in terms of Section 36 of the Constitution is justified or not. This is one aspect also one needs to consider. And then if you find that there is no justification for the discrimination, then only then one can declare the legislation inconsistent with the Constitution and declare it invalid and refer it to the Constitutional Court, of course, because it's not final until the Constitutional Court determines.
If it doesn't involve discrimination, do you remember, are you familiar with how you deal with it?
Pardon?
If it does not involve unfair discrimination, are you familiar with how you deal with it?
If it doesn't involve unfair discrimination, I don't think one would be justified to declare it inconsistent with the Constitution.
So you think
this matter was the only matter, as I say, that dealt with this, and then I went through all the stages.
Yes.
And because it really proved to be unfair to the citizens residing in this part or across the Kai, compared to those that live in the other areas of the same province, it was unfair. I had to declare it unconstitutional.
Okay, there are two types of discretion in law. Are you familiar with the two types of discretion? And if you are, do you know what the differences are between them and what the legal significance is of those differences?
CJ, yes, there are two types of discretion. We talk of a wide discretion, and then we talk of a limited discretion, which is like restricted. One is restricted to interfere with a decision of a court where it has, if we're to go with a wide discretion, if the court concerned had an option of various, had various options to choose from, and in the exercise of its discretion went with one option which is available to it to choose. In that way, one would be very restricted to interfere with the decision of the court. Also, in wide discretion, that it involves the appeal court dealing with a wide, has a discretion to interfere with judgments, but the wide discretion would involve, would not necessitate a finding of the exercise of a discretion or irregularity in the exercise of the discretion, if I may put it that way. It does not necessitate that. The court, in its inherent powers, can, without such a finding, substitute its decision or act as a court of first instance. When it comes to limited discretion, that necessitates a finding of an exercise of discretion not judiciously, if I may put it that way, an irregular exercise of discretion, that necessitates a finding of irregularity in the exercise of discretion.
I will now give the Deputy President of this SCA the opportunity to put questions.
Thank you, CJ. Thank you.
Thank you, Chief Justice.
Good morning.
Good evening, Judge Mjali.
Good evening, Deputy President.
Whilst you were being questioned by the CJ, you said that you went to the Eastern Cape once your appointment was in place. Did I understand you correctly?
Yes, Deputy President, save for, I said to the CJ, I didn't go to the Eastern Cape immediately. I stayed at the Land Claims Court and only joined that court after my appointment was approved. That is after, meaning it had been it had been signed by the President, but because the JP, I mentioned, that he said he had nothing to do, he had no work for me, he won't have anything for me to do, I then took advantage of that hiatus to finalize my matters in the Land Claims Court and only joined the Eastern Cape in 2011 at the beginning of the term.
But when, with effect from when were you appointed a judge of the Mthatha Division of the High Court?
I was appointed as, my letter of appointment, Deputy President, stipulates the 31st of October 2010 as my date of appointment as a judge of the High Court in the Eastern Cape.
And what you are telling this commission was that the judge president of the Eastern Cape came here in October.
That is correct.
Was present when you were interviewed. The commission recommended your appointment. You were appointed because the JP had said there was a vacancy. And once you were appointed, the JP said, I didn't want you for now.
Deputy President, if you may understand the legal implications, I come to this body. This body recommends my appointment. Until the president of the country signs on the dotted line, makes the appointments, it's only a recommendation. That is the legal position. It doesn't mean that because I'm recommended for appointment to a certain position, that the appointment is done, it's finalized. It's a pending process. And until the president of the country signs on the dotted line, that appointment.
Sorry. His question is different.
Yes.
He was just asking you to confirm what the judge president of the Eastern Cape said after having been here. That was his question. Deputy President? He was saying to you, do you mean that the judge president of the Eastern Cape came to this body, was present when you were interviewed, knew about the fact that you were recommended by this body for appointment, but when you got to the Eastern Cape, he didn't want to make use of your services immediately? That is what he was putting. I guess that your answer should be yes.
CJ, may I, for the benefit of the commissioners who do not know the story behind here, elaborate on this?
No, hang on. Don't elaborate yet. Was that the position taken by the judge president of the Eastern Cape? Namely, he didn't want to use you for a certain time?
No, CJ. The judge president of the Eastern Cape sent me a program on the very next day after returning from the interviews which were held in Cape Town at the time. It was on the day after I was interviewed, and it was mentioned to me that I had been recommended for appointment in Mthatha. Then I got a roster emailed to me, placing me, I remember correctly, quite vividly, in a circuit court for 3 weeks at Lady Frey, whilst my acting appointment with the Land Claims Court was very much in extent. And following the deliberations we had with the JP, because he could not understand why I could not drop everything there and join the Eastern Cape even before the president had signed. And when I brought these anomalies to his attention, that's when he said, even if you get appointed, I think it was after I was appointed, the 31st of October. The letter of appointment came and I was ready, and BAM JP was ready to release me. I then communicated with him. But because I had not made myself available at the time he wanted me, and it was the last term of the year, he said, well, I won't have anything to do with you. I won't have anything for you to do. And then I wrote this, there's something in writing, I wrote this. It's in the files in the Eastern Cape. I said, well, because you said you won't have anything to do with me, I will join the Eastern Cape bench then, beginning of the term on the following year, which was 2011, and I did just that.
Whilst I hear your response, I have difficulty in understanding your explanation, but I'll not belabor the point, I'll leave it at that. In paragraph 16.5 of the questionnaire, you listed 2 partly head matters that were still outstanding. That's at page 14, paginated page 14.
That's correct, DP.
And what is the current status of those matters?
The partly head matters, you mentioned paragraph 16 of the questionnaire, DP?
Oh, I'm sorry, 17.1, that's where you listed partly head matters.
The partly head matters, they are still there, DP. Why? These are lengthy trials by their very own nature. One of these trials, the first one, yes, the first one, after I left the SCA, as per my undertaking when I joined the SCA, I spent some time with these 2 partly head matters and up to December 15th when I stopped. The first one posed some security concerns. The accused number 2 there was gunned down. It has its own difficulties, but there we have managed to get to the end of the state case. Few weeks ago, I dismissed an application for discharge in terms of Section 174 of the Criminal Procedure Act. So we are at the defense case there. Considering now that there's only one accused, that partly head matters, that matter should not take long. I made a request to be accommodated in this term to deal with it. My request was not accommodated. The second one, it's a case that I had started last year at the second court in Tabankulu. It has 8 accused there. It's a long case by its very own nature. We are at a trial within a trial. But there also, I made a request to be accommodated within this term. And I'm happy to report that I have been given 5 weeks to deal with this matter. I am hoping that the 5 weeks will do the necessary impact.
I see from a document that you provided me with that that case was initially scheduled to, or the trial to resume from 31 October 2022 to 18 November 2022.
That's correct, CJ, DP. Because, sorry.
The
My apologies.
accused persons out on bail or in custody?
One was out on bail, that's the one that was gunned down. And then the other one is in custody.
And what about the other 5? Because you said there were 8 accused.
No, this is the matter, I'm talking about the first matter now, DP. Maybe I misunderstood your question. With regard to the second matter, all the accused are out on bail.
The matter was scheduled to resume from the 31st of October to 18th of November.
That is when I was acting at the SCA. And as such, I made an undertaking with my JP that as soon as I return from the SCA, I will deal with this matter. I did just that. The realities of dealing with a criminal matter are not, do not go according to one's wishes. I spent time there, and this is one of the cases I said I dealt with immediately after my return from the SCA. My term there ended on the 30th of November. I returned home in time to carry on. On the following week after returning from the SCA, I was on circuit. I carried on right through to the 15th of December, trying to deal with these issues. There are difficulties that one experiences with crime, one being the load shedding. In Tabankulu, in the magistrates' court, DP, you will know this maybe from your experience in the Transkei. This is one of the most rural courts. The load shedding will hit. At first, there was no generator. There is a generator. But because of the procurement procedures pertaining there, when the diesel is finished, then a new process has to start. It is frustrating. The second would be, one is dealing with 8 accused here. With criminal trials, anything is possible. It has happened many times that we would set aside time to try and finalize a matter. One accused will fall sick. You cannot carry on without constituting an irregularity, committing an irregularity. The trial has to be adjourned. There are so many issues that prove to be challenges for criminal matters to be finalized. Either the court machines are not working. There are so many things that are really frustrating. So this one, in the 5 weeks coming, which will take me through to the end of term, I am hoping that it will be brought to finality?
What in fact I sought to put to you was this. Dates are arranged with you that this trial will run for 3 weeks. You receive an invitation to go to the SCA, you abandon everything, you choose to go to the SCA. When Section 35(3)(d) of the Constitution says the accused are entitled to a fair trial, which includes the right to have their trial begin and conclude without unreasonable delay.
DP, that is very much true. But I am not the first judge who has been released to go to the SCA. This was done, this is the exercise that involved, with the greatest of respect, you, the JP of the province, as well as the practitioners who represent the accused.
But my sense is that you put your interest above those of the accused because you had this opportunity to go and serve in the Eastern Cape, rather in the SCA.
DP, with the greatest of respect again, going to serve to the SCA is not about me. It's about a need to serve in that court. There is a request. This is discussed with the very head of the court who is seeking my services at the SCA. I disclosed it, that I have these commitments. From what was discussed, I can say sitting here, I'm probably one of the judges who was not committed, who was called, who was not so committed, who was called to serve at the Supreme Court of Appeal. It is not per se putting my interests first. It's not about me. It's about serving in a court.
I'm raising this with you in fairness to you because as I'm sitting here, I know of a colleague from the Eastern Cape who was invited to come and act at the SCA in November, and that colleague said, November is out of the question for me. I would have loved this opportunity. It would have been my first acting stint at the SCA, but I have this commitment because November has been arranged for my partly head matters, which I want to conclude.
DP, once again, maybe I'm going to refer to many judges that get invited to act in that court, who also have commitments, which commitments are even much more longer than my commitments. I was asked, you remember when you invited me, you asked, you had spoken to my JP. You invited me to provide you with a list of my partly heard matters, with a list of my reserved judgment. And you, nevertheless, with that knowledge, were okay with me going to serve in that court. I'm not the first judge. I know of colleagues in my division who have matters where accused have been incarcerated for longer, but nevertheless get invited to act in that court and get invited to act in that court for much more longer periods than I acted.
I chose not to enter into the debate of who invited you to go and act in the SCA. The feedback which the Commission received from various law bodies and individuals, we have a letter from the Law Society of South Africa.
Yes.
That says that it was too early for you to raise your hand because you have only acted at the SCA for one term, a short term at that.
May I respond?
Please do.
CJ and the commissioners, it is true that I acted in the SCA for the shortest of terms. The LSSA, my reading of the LSSA commentary is that purely because I had not acted in that court longer than many other candidates, I am disqualified. There is yet another reason which I will deal with as and when time comes. But insofar as this requirement of acting in that court, if one has regard to the provisions of Section 174 of the Constitution, which deal with the appointment of judges which deals with appointments of judges. Nowhere in that section is there any requirement of a long acting stint. Much as it may be desirable, the long acting stint, in my view, is not a requirement in terms of Section 174. Yes, that section says might have acted, and that might provide the commissions with better insight into a candidate's capabilities. I looked at this. There is now an accepted document which provides guidelines for appointment of judges. At paragraph 12 of that document, it is said that, I want to quote this paragraph. It says it is desirable for candidates to have acted in a judicial or quasi-judicial role, but this is not an essential requirement, particularly when it comes to an appellate court, including the Competition Appeal Court, Labor Court, Supreme Court of Appeal, and Constitutional Court. And it goes on to say, appellate experience, both as a practitioner as well as or as an acting judge would be the relevant consideration in the latter circumstance, but it should not be given excessive weight over other considerations. In me, you are dealing with a person who has been a judge, now including the acting appointments in excess of 14 years. In my experience as a judge, I have had to sit on appeals, full bench or ordinary appeals. The situation that pertains at the SCA, that being a court, an appellate court, is not, yes, it is different, but there are similarities. There are lessons one can have learned from sitting in appeals, full bench or otherwise. There you deal with other members of the bench, you work as a team, you produce judgment. A similar situation that finds itself at the SCA. Apart from that, in my 14 years experience, I have grown. I have written judgments which found its way to the Supreme Court of Appeal, many of which were dismissed at petition stage. Many of those that went through appeals were confirmed. I have penned judgments that have been confirmed by the Constitutional Court. This was as early as when I started acting in Kimberley, 2009. So, the issue of not having acted sufficiently in the view of the LSSA, which is not consistent with the requirements as set out by the Constitution, as well as the document that has been accepted, which does not place a requirement to act at a higher court beyond desirability, and which goes on to specifically say acting in that court should not be given excessive weight.
I don't want you to
beyond
repeat
other considerations.
To repeat what you have already said, Judge Mjali, I'm sorry. But your point is clear. You are saying, one, acting in the SCA is not a requirement.
Yes.
It's not in the Constitution, you say. And you say the document of the criteria that has been adopted by this commission also makes it clear that the fact that somebody has not acted should not be given excessive weight. Those are the points you make, and you make the points that as a judge of the High Court, you have sat in many appeals which you submit is the same thing that happens in the SCA. That's the point, that's your response.
Correct, CJ. May I just add, if I may, through you, CJ?
Yes.
That if what the LSSA would be taken as...
Maybe I should just say this because maybe it will help.
Yes, CJ.
The document you are reading is approved by this body. So this body doesn't take the attitude that if you have not acted, you are disqualified. And it doesn't take the attitude that not having acted in a court must be given excessive weight. So you can accept that. But I think the point that the Deputy President was making was simply that when you have somebody who may have acted for a longer period and you have acted for a shorter period, that person may well have an advantage over you depending on other things. I think that's basically the point he was making. He was not saying you are disqualified.
Thank you, CJ. Maybe that was just the point I was going to make. Thank you, CJ. I'm covered there.
Thank you, CJ. I'm looking at the letter of support in your favor by a firm of attorneys, Messrs. H.S. Stoney Attorneys.
Yes, TP.
Going to page 8 of that letter, what struck me as somewhat odd is the fact that he says that in a matter that served before you, counsel stood up in court and said that he is appearing for the applicant. The instructing attorney did the same, and then this is what this firm of attorney then says. Madam Justice Mjali navigated well, albeit very carefully, in handling both legal representatives, and in her usual and rare sense of humor, allowed both counsel to address her on the topical issue. The way I understand it is that you allowed two legal practitioners representing the same litigant to address you. Is my understanding of what is said in that letter of support?
That is
Correct.
what is said in the letter, but what played out in court, the counsel who was representing the applicant in that application ended up withdrawing, and it is only then I then allowed the attorney who said he wanted to lead a counsel that they had briefed, a situation which is unprecedented in our law. The attorney stormed in court. There was a corresponding attorney. And then this one arrived in court, and there was an adjournment. And after the adjournment, then counsel stood up and said, the attorney would want to lead him. And then I asked myself, what kind of animal is this, if I may use this for lack of a better word? And then I inquired from the counsel that appeared before me at the time as to whether anything like that, a counsel would be led by an attorney. He didn't want to give me a straight answer initially, but I probed, and he initially ended up saying that his mandate has now withdrawn, and then only then I allowed the attorney to address me and to take the argument forward. It's not a question of me allowing an attorney to address me when there was counsel that was briefed to do so.
Well, for your benefit, that is not unprecedented. I argued the matter in court, led counsel, and the matter is reported.
Thank you.
You have already told this commission that you have been on the bench for 14 years.
Yes, Deputy.
And this is what I want to explore with you next. Paragraph 16.2 of the questionnaire. Which of the judgments or cases have been reported? Although you have listed 4 of them, in effect, only 1 judgment has been reported. 2014 to South African criminal law reports. Are you there, page?
Yes, I'm looking at the list of, yes. Yes. Kotliso versus the state, yes.
I accept that that one has been reported. What about the other 3?
There's Mzimkulu Jigijela. You find this judgment on Safli. There's Zondi, there's Sparni. All those judgments are on Safli.
Yes.
And yes.
Judgments of the Supreme Court of Appeal are published as a matter of course in Safli. So you can't count them as having been reported.
Yes.
Thank you.
May I don't really, I'm not sure if I get the question here. Is it about the number of judgments that I've listed as reported and one of them being reported in the SACR? Is it about the paucity of judgments there?
Yes.
If I may comment on that.
That have been reported,
Yes.
bearing in mind that you have been on the bench, as you have told this commission, for 14 years.
DP, I come from a school, and in fact, this is the product of my training in the aspirant judges course, where we were cautioned against reporting judgments for the mere sake of it. This judge who never marks her judgments reportable. As to how this one found its way there, I simply do not know sitting here. My commitment is to dispense justice. And when I have done so, then I'm satisfied. I have written many judgments which found their way. I don't know what goes into reporting judgments. I never really bothered myself about that, as I know that it is the litigants who want justice, and it is the litigants who will want the courts to adjudicate upon their matters and decide thereon. Coming from the school of being cautioned against reporting for the mere sake of it, it could do with that. It could also do with the fact that I have seen many judgments in the law reports where one would ask, why was this judgment in the law report to start with? My experience at the SCA and also sitting as a judge with other colleagues, we would deal with the issue of whether the judgment is reportable or not. And invariably, I never mark my judgments reportable. And I know some people might criticize me on that.
Thank you. The last point I want to explore with you relates to paragraph 16.1.
Of the questionnaire.
Of the questionnaire. These cases where you have written the judgment which you regard as being the most significant and why. You have listed some judgments, pages 12 and 13.
Yes.
But you haven't stated why you consider those judgments significant.
Starting with the first judgment I have listed in the judgments in paragraph 16.1.1. This is my very first judgment in the SCA. In that bench.
I'm sorry, Judge Mchali.
Yes.
Deputy President, is your question, are you inviting her to say why they are important, or are you asking why she omitted to specify why they are important?
Why she didn't respond to the second part?
Yes, okay. Okay, you understand, Judge Mchali?
Information sought in that clause.
So the question is not to invite you to say now why the judgments are important, but to say why you did not respond to the second part of the questionnaire, which required you to specify why you thought they were important.
Yes, CJ, if one looks at the list of the judgments that I have given, in brackets, I have mentioned next to the judgment, there is some kind of elaboration as to why the judgments are regarded as important. If one looks at the very first one, I say this is an SCA judgment which was unanimous, and this judgment was a product of me convincing 3 senior members of the bench who were initially against me, but having discussed this after the hearing and having heard this matter and hearing me posing questions to the respondents in this court, in that court, they were all of the view that I was the correct one. This is why I say this was important. It was my first one, but I took it upon myself to kind of sway the other members to agree with me. And this was a unanimous judgment because of that. I've written NOSIPO, this is now 16.1.3. I've given the reason why I thought this judgment was important. It was confirmed by the SCA and the Constitutional Court. In fact, the SCA was overturned partly for having
overturned you in one respect.
It overturned me in one respect, but the Court agreed with me, and the final answer there was Mjali was correct, and compliance with Mjali's order was the way to go.
Well, I just wanted to say, Judge Mjali, your answer was you have specified why they are important. You haven't been invited to elaborate.
To elaborate.
Yeah.
Thank you, CJ. Invariably, in all these judgments, in brackets, I have stated why I thought these judgments are important.
Thank you, Judge Mjali, and thank you, Chief Justice.
Thank you,
Thank
Minister.
you.
You are covered. Thank you. I don't, Commissioner Marumwachai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon.
Or it's good evening, I think.
Commissioner, good evening, yes.
Let's start from the case that you are talking about, and the Dabeni case, and I've just read now the Constitutional Court case, and you're quite right.
Yes.
But I just want to go back to your original case. As I understand it, and correct me if I'm wrong,
Yes.
At the core of it, it was an application for leave to appeal. Is that correct?
That is not correct, Commissioner. I must have made a mistake. I first gave a judgment, my reasons for the order. In fact, it was immediately after hearing arguments in that case. I then gave an order.
Let me put it this way. It was an application for leave to appeal.
Which I refused, and then what happened there was when that failed and they were taken to task for, now there was an application for them to be declared to be in contempt of my court order.
Okay, Judge, I appreciate that, and you are quite right, but I want to deal with a specific issue in respect of your judgment. And I just want to see how you view applications for leave to appeal.
Yes.
And I just want to understand what is the test that should be applied, and whether, because there are two judgments, there's this one and the other one that you placed here. I just want to get your appreciation of the test, Section 17(1) of the Superior Court Act. What is the actual test for applications for leave to appeal? And do you apply the test as it is stated there, or do you only focus on at least one part of it, which is prospect of success?
Professor, the test is Section 17 stipulates that leave to appeal may only be granted where the court of first instance is of the view that an appeal court faced with the same facts would come to a different conclusion. And it goes further to say, beyond that, leave to appeal would be granted in circumstances where there are special or circumstances
let me try to assist
that
you.
need to be dealt with by the court.
I apologize, Judge. Let me try to assist you for time's sake. My understanding of the test, and you correct me if I'm wrong,
Yes.
it has two parts, three if you like. The first one will be, would the appeal have a reasonable prospect of success? That will be the first one. The second one then will be, there is some other compelling reasons why the appeal should be heard, including conflicting judgments. Now, what I want to converse with you is, it appears when I'm reading your judgment that you overemphasize the first leg, and it doesn't seem like you consider the second leg at all. Other compelling reasons that might lead you to decide differently. What is your view on that? And that will be my last question on the issue.
Professor, I do consider other compelling reasons.
for a case to be in an application for leave to appeal. In my conclusion, yes, I might in some cases have considered only the first leg, but as in Lumayo, it is well documented that no judgment could be all-embracing. It doesn't mean that sitting there and considering this and knowing that it is also one of the reasons why a matter can be referred to an appeal court. But having not passed muster on this one, I don't think it is necessary for me to then go on with all the other issues. It doesn't mean, as it might appear on my judgments, that I didn't consider the other aspects, which I, in terms of Section 17, should consider.
No, thank you very much, CJ.
Thank you, Commissioner Nyambi.
I'm fine, CJ.
Thank you very much. Commissioner Moimang.
Thank you, Chief Justice. Good evening, Judge. Just one question.
Good evening, Commissioner. Sorry, I thought you were still speaking. I'm very sorry about that.
On the side.
Yes.
Look, I'm trying to get a sense in terms of the mechanism and systems in place in terms of acting judges, so that one get an insight into the structures of the Supreme Court of Appeal, because there is an expectation that a platform like that is created, there will be systems in place to ensure that there is constant and consistent feedback to the acting judges with a view to broaden the pool of the judiciary. Are there enough systems in place? Because coming from, as part of the JSC, coming from Parliament, our appreciation of the judiciary is an arm of government that police the nation and its rulers, and then therefore our expectation is that the judiciary owe everyone the duty to do their utmost best, and that's our appreciation of the judiciary. But it becomes important that probably in recommendations you can reflect on that in terms of what systems are in place to guide the new emerging judicial mind that are afforded that opportunity to shine. Are there systems in place, the feedback practices, so that as you go back and come back, there is no repeat of some of the issues that are raised? Thank you, Chief Justice.
Thank you, Commissioner. I just want to check if I understood your question properly, that as the position is now, are there proper systems in place to allow people to be recognized for acting. Do I get you correctly?
The feedback, are there systems in place to give you feedback, to give those that are acting feedback in terms of the work that they are doing? So that as you go back for another term, you know that this were the expectations, and I'm moving in the right direction. Thank you.
Thank you, Commissioner. I think this depends from court to court. I will now not confine myself to the Supreme Court of Appeal. It depends from court to court. I started acting in Kimberley, in the Northern Cape. The JP was hands-on. He maintained an open door policy to say, you get stuck, you come knock to my door, you knock at my door. Any question, there's never a foolish question. You are free to come to my chambers, anything, there are colleagues there that you can approach whenever you think you are stuck with this. You can also do so to kind of double check if you are going to the right direction. My experience in the Northern Cape was shortly before I left, the JP called me in. I'm not the only acting judge that was there who had the similar experience, to say, where did we fail you? I have never heard of it in other divisions. I don't know what goes on there. This doesn't mean to say it doesn't happen. But I was quite impressed by the JP saying, criticize me, where did I fail you? How could I improve how could I have improved your experience here? This is now one aspect that one can never, it's invaluable. As acting judge, you might not know if you are going to the right direction. You consistently need that form of confirmation or correction when it is necessary. At the SCA, this happens in the form of comments being made to one's draft judgment. The conferences that are held where one can always learn from those that have been at the helm of things there. This is the kind of feedback that one gets. I'm not sure if, as things are, there are sufficient systems in place to give one a view of how one fared. Yes, the senior colleagues might do so, but one wants an overall feedback as to how one fares, where are the areas of improvement. This is how people grow. To be shown where you can improve, that to me is something that should be seriously taken into account.
Thank you.
Thank you. I hope I have answered your question.
No, thank you. Thank you, Chief Justice.
Thank you.
I'm sorry, I thought you had already, I thought you had already signified that that was your last question. Thank you very much. I don't see any further indications of hands. Judge Mchali, thank you very much for having availed yourself. We have come to the end of the interview. You are now excused.
Thank you, DCJ. Thank you, commissioners, for having me. I truly appreciate the opportunity.
Thank you.
Thank you.
There obviously won't be deliberations because we are still continuing tomorrow. So, Two more candidates. Thank you. Thank you. I think we are done for the day. Thank you very much.